It's not to me. Committee will now come to order. Today we will hear from a number of witnesses on modernizing the Natural Gas Act to ensure that it works for everyone. Before we begin today's opening statements, I would like to make a few announcements about today's proceedings. First, I would like to remind everyone in the audience that any manifestation of approval or disapproval of committee proceedings is in violation of the rules of the House and of this committee. Prohibited acts include holding signs, yelling statements from the audience, and any other acts that could disrupt today's proceedings. I ask all persons in the audience to refrain from such actions during today's hearings. Second, I would like to acknowledge that Congresswoman Fletcher from Texas is scheduled to be here, who has joined us for today's hearings. We're happy to have her, and under the committee rules, our colleagues are welcome to join us for other hearings, although they are unable to give opening statements or question witnesses. The chair now recognizes himself for 5 minutes. The Natural Gas Act was enacted in 1938, created to regulate the interstate transport of natural gas. Today we convene this hearing to further examine the function of this legislation and its broad impact on our communities. To this day, the Federal Energy Regulatory Commission continues to manage pipeline applications through their authority under this act. However, in recent years, the Commission's administration of the act has come under scrutiny. Specific concerns include issues related to rehearing processes, tolling orders, eminent domain, landowner rights, and the impact of this infrastructure on climate change. For example, FERC's ability to protect natural gas customers against unjust and unreasonable rates is compromised by its inability to set a refund date, and unlike the Commission's ability to do so under the Federal Power Act for electric utilities. This inequity exists because Congress amended the Federal Power Act in 1988 to provide FERC with refund authority in electric rates, and has yet passed a subsequent fix to the NGA to provide refund authority on par with the Federal Power Act. Further, disagreements exist among FERC commissioners, stakeholders, and natural gas pipeline companies as to what extent, if at all, FERC must consider the climate impacts of its pipelines as a part of its determination that the project is or is not in the public interest. I thank our witnesses for their participation in today's hearing and look forward to discussing how to make sure this law is working in support of everyone's interest. The chair now recognizes Mr. Upton, ranking member of the Subcommittee on Energy, for 5 minutes for his opening statement.
Well, thank you, my friend and chairman, for holding today's hearing to examine the role of natural gas in our economy and FERC's responsibilities under the Natural Gas Act. So we know that pipelines are indeed the safest, most efficient way to move energy long distances, and they are certainly vital to our nation's economy. Over 2.5 million miles of energy pipelines crisscross the nation already, and the need for safe and reliable energy infrastructure continues to grow. Natural gas is an abundant resource across the country, and new discoveries in extraction methods, thanks to fracking and directional drilling, have led to a dramatic rise in domestic production. America is now the world's leading producer of natural gas, and we are certainly reaping the benefits. The economy is stronger, the shale boom has created millions of jobs, and we are more energy secure, in fact independent, and natural gas is helping to reduce carbon emissions both at home and abroad. In Michigan, we've cut our emissions by over 25% in the last decade thanks to natural gas. The Natural Gas Act is the principal federal law that regulates the sale and transportation of natural gas in interstate commerce. And while the natural gas industry has undergone remarkable changes over the decades since its passage in 1938, the law has withstood the test of time and does remain sound. Through the passage of the Natural Gas Act and its amendments, Congress recognized the need to establish a framework to encourage competition within the natural gas industry, protect consumers from monopoly pricing, and promote interstate commerce. As a result, pipelines today are subject to significant federal oversight and regulations. Under the Natural Gas Act, FERC has jurisdiction over virtually all aspects of interstate pipeline operations. Before a pipeline is constructed, FERC must conduct a rigorous environmental review and issue a certificate that finds the pipelines necessary in the public interest. FERC also has the obligation to ensure that consumers are protected and the rates charged for interstate pipeline services are just and reasonable. FERC has ample authority under current law to require prospective changes in the rates charged by a pipeline company when it can be demonstrated that the rates are no longer just and reasonable. For example, following the passage of the Tax Cuts and Jobs Act, FERC required all 129 jurisdictional gas pipelines to make informational filings, and many operators ended up lowering their rates for customers. FERC's regulatory oversight extends beyond pipeline siting and rates. If a pipeline operator wants to shut down a pipeline facility that's uneconomic, they've got to seek permission and approval from FERC in order to protect consumers from service interruptions or rate increases. Despite the fact that pipelines are the safest, most efficient form of transportation, and despite the fact that natural gas is helping to reduce CO2 emissions across our economy, it has become increasingly difficult and costly to make it through the FERC siting process. Pipeline opponents are challenging projects at virtually every turn, using every tool to delay or block pipeline projects. States are getting more involved, too, by delaying or withholding Clean Water Act permits. Increasingly, the courts are being asked to adjudicate these cases, which could have broad implications for the Natural Gas Act. FERC, to its credit, does seem to be doing what it can to make informed and careful decisions. Just last week, FERC issued a key decision clarifying what is the congressional intent that eminent domain authority under the Natural Gas Act applies to state land. To be clear, states do not have a veto authority over rights-of-way on state lands when an interstate pipeline has been determined to be necessary and in the public interest. In a separate action, FERC created a new division to focus specifically on landowner issues and to be more responsive to the public, a good thing. It appears our current framework is working, but as we move forward, I'm going to certainly continue to remain open-minded about what, if any, changes might be necessary to improve the Act. And, Mr. Chairman, while I look forward to hearing from our witnesses today for sure, I would be remiss not to mention that we have unfinished work to reauthorize the Pipeline Safety Act, which expired last September. As you know, PHMSA's authorization expired back then, and work on the reauthorization bill appears to have been stalled between our two committees. Members on this side of the aisle are eager to get the bill back on track to send to the Senate and then to the President. Would like to think that we might be able to get a commitment on this important bill before the day is over. And with that, I yield back.
The gentleman yields back. The chair now recognizes Mr. Pallone, chairman of the full committee, for 5 minutes for his opening statement.
Thank you, Chairman. Today's hearing is long overdue. For the first time in many years, the committee will take a broad look at the Natural Gas Act and how the Federal Energy Regulatory Commission implements its many provisions, and not just those dealing with infrastructure, permitting, and siting. It's been too long since this committee explored pricing and what consumers pay for natural gas. Customers have little recourse to request refunds for many overpayments they make. Meanwhile, pipelines get to use certain pricing provisions in the law to thwart the inadequate consumer protections in other parts of the Act. Representatives Butterfield and Long have introduced bipartisan legislation to help address this problem. They propose a simple revision to the Natural Gas Act mirroring the refund authority for electric consumers in the Federal Power Act, and I commend them for their important efforts to protect consumers. Of course, it's impossible to ignore the issue of pipelines, their placement and impact on climate change and landowners. FERC has done itself no favors by taking actions that have stoked the controversy surrounding these matters. Last week, Chairman Rush, Tonko, and I released the Clean Future Act, our climate plan to achieve 100% clean economy. That bill makes clear that FERC should be considering the climate impacts of pipeline proposals. And this is necessary because several commissioners still act as if FERC need not consider climate change as part of its public interest determination. They're essentially ignoring the court's decision in the Sable Trail case that specifically told FERC to look at greenhouse gas emissions. FERC isn't even considering climate in its National Environmental Policy Act reviews. It's alarming that FERC looks at all other environmental impacts of pipeline projects, yet refuses to take climate change seriously. The Natural Gas Act provisions in the Clean Future Act also highlight the need for a regional review of pipeline projects. FERC must take a more holistic view of the pipeline's infrastructure already serving particular regions in order to determine whether new infrastructure is really needed. I'm concerned FERC is simply approving duplicative pipelines with 60-year lifespans under the guise of market need, even when those pipelines are not really necessary. The Atlantic Coast and Mountain Valley Pipelines projects clearly illustrate the need for regional review. Both pipelines cross roughly the same areas in the Mid-Atlantic region, and in some instances impact the same communities and landowners. Well, why do we need that duplication? And while work on both pipes has been halted, much of the land damage has already been done because FERC allowed these duplicative projects to begin construction. Last week, just after we announced this hearing, FERC announced it was creating a new division to expedite landowner-related pipeline appeals known as rehearings. Now, that sounds good, but we'll have to see if FERC is really getting the message. The fact is FERC's process for siting and constructing interstate pipelines is not working, especially for landowners. FERC should ensure a fair and equitable process for those seeking to protect their property, but the current process really only considers the needs of the pipeline companies. And today we'll also discuss issues surrounding eminent domain. FERC recently put forward a declaratory order supporting the use of eminent domain to take state-owned lands for Penn East, a proposed pipeline between Pennsylvania and New Jersey. For an independent regulatory agency to help a private party seize state lands to build a pipeline is as wrong as it is bizarre, and FERC should leave the constitutional question on state sovereign immunity to the courts instead of pushing the Trump administration fossil fuel agenda. And before I yield, I wanted to yield a minute or so to Mr. Butterfield, but I wanted to welcome Representative Lizzie Fletcher of Texas, who has tremendous knowledge of the industry. Thank you for joining us. And I also want to insert for the record a letter, Mr. Chairman, from the Industrial Energy Consumers of America, highlighting several critical issues, including pricing, reliability, and the need for greater scrutiny of natural gas exports to ensure they serve the public interest. And I'd like to yield my remaining minute to Mr. Butterfield.
Thank you very much, Mr. Chairman. I won't take the full minute, but thank you for yielding time, and let me join with you in thanking the four witnesses for your testimony today. Mr. Chairman, I will take an extra second, if I can, to welcome my constituent and neighbor, Rich Warsinger. Rich is the director of Wilson Energy, the municipally owned electric and natural gas utility in my hometown of Wilson, North Carolina. Rich has over 35 years of experience in the utility industry. Nearly 20 of that has been in the eastern part of our state. He understands the industry and the challenges that utilities like Wilson Energy face in providing energy to their ratepayers. Rich will be a valuable voice in today's hearing, and I thank him so very much for coming. Thank you, Mr. Chairman. I yield back.
The gentleman yields back. The chair now recognizes Mr. Walden, ranking member of the full committee, for 5 minutes for his opening statement.
Morning, Mr. Chairman, and I want to welcome our witnesses and our guests today, and we appreciate you holding this hearing. Members will get a great opportunity to examine the role of natural gas and the challenges and opportunities to upgrade and modernize our nation's natural gas pipeline system. Abundant and affordable domestic natural gas has enabled the United States to become the world's #1 energy producer, while simultaneously leading the world in carbon emissions reductions. U.S. consumers are benefiting from low and stable natural gas prices. Our economy is benefiting from the jobs and investments in new infrastructure and manufacturing, and the world is benefiting from a more reliable and stable trading partner. Over the last decade, the United States has become more energy secure than ever before. It wasn't long ago when we thought we were running out of natural gas. Today, we are energy independent. We are net exporters of natural gas, and our prices remain historically low and stable. Now, we didn't get here because of some government mandate or regulation. We owe it to technological innovation and American ingenuity. They unlocked natural gas resources that once were inaccessible. All 50 states are benefiting from the affordable, reliable resources right here in our own backyard. We don't have to depend on Russia or the Middle East for imports anymore. With energy independence, we're creating millions of American jobs, good-paying American jobs. And our economy and energy security is stronger than ever before. Cheap domestic natural gas is also helping to bring jobs back to the United States, where it's used as both a fuel and feedstock in manufacturing. American natural gas is also good for the environment. Our carbon emissions have plummeted as more natural gas is used to generate electricity. And our trading partners around the world are lowering their emissions by switching from dirtier sources and unstable suppliers of energy. Thanks to cleaner burning natural gas, America is leading the world in carbon emissions reductions, beating the projections of both Waxman-Markey's cap and trade bill that some of us had to suffer through the markup on here a few years ago, and the Paris Climate Agreement. This goes to show why Republicans continue to reject carbon taxes and the very restrictive regulations of many on the other side of the aisle, some of whom want to keep all this energy in the ground, quote unquote. We're focused on innovation. We're focused on market-driven solutions because they've delivered real results for the American people and for our friends and allies. As the United States continues to emerge as the world's global energy superpower, we must also modernize our infrastructure, especially this vast network of pipelines that we rely upon to move energy safely from where it is produced to where it is consumed. And we have a lot of work to do. Due to pipeline bottlenecks, they recently had to import Russian LNG into Boston Harbor. Amazing. Pipelines are simply the safest, most efficient way to move energy. Congress recognized this fact back in 1938 with the passage of the Natural Gas Act. And while the industry has undergone tremendous change, this statute continues to guide our policy today. Natural gas pipelines are highly regulated, as they should be. The Federal Energy Regulatory Commission reviews pipelines to ensure they are necessary in the public interest. FERC also reviews pipeline rates to ensure they are just and reasonable. Pipeline developers are required to complete a rigorous permitting process, sometimes lasting several years, with multiple federal and state agencies, as we'll hear from our witnesses today. The pipeline permitting process has become increasingly complex and very challenging, not to mention expensive. FERC and gas pipeline companies have been taken to court by some landowners, environmental groups over property rights and the scope of environmental reviews. States like New York and New Jersey are attempting to delay or block pipelines by withholding federal permits and challenging the use of eminent domain. Ironically, and unfortunately, without access to natural gas, some of these states continue to use heating oil, which is more expensive for consumers and produces more greenhouse gas emissions. Through these challenges, FERC has done a good job of carrying out its responsibilities under the Natural Gas Act. The record shown FERC to be focused on protecting interstate commerce and fair competition. FERC has also done a good job of balancing the public interest with private property rights, and the announcement of a new division to respond to landowner requests is a testament to their commitment, and I applaud that. I plan to use today's hearing to explore these issues through the lens of the consumer and ask some important questions. What is necessary to continue to maximize the benefits of natural gas pipelines for the consumer, for the American economy, and for the security of our nation? And Mr. Chairman, as you know, we have another subcommittee convening downstairs, and then we have the coronavirus all-member briefing over in the Capitol at 11 o'clock. So I know some of us will be going to all three of those things. So I state that at the head end. I return 9 seconds.
I thank the ranking member of the full committee for his comments. The chair would like to remind members that pursuant to committee rules, all members' opening statements shall be made part of the record. I would now like to welcome our first panel of witnesses for today's hearing, the Honorable Cheryl LaFleur, former chair of the Federal Energy Regulatory Commission, Mr. Mike Mahanan, Senior Vice President, General Counsel, and Secretary, Boardwalk Pipelines LP, who is testifying on behalf of the Interstate Natural Gas Association of America. Thank you. Richard Woznier, Treasurer, Board of Directors, American Public Gas Association. And Dr. Susan Tierney, Senior Advisor of the Analysis Group, Incorporated. Thank you, the witnesses, for joining us today. We look forward to your testimony. Before we begin, I would like to explain the lighting system. In front of you is a series of lights. The light will initially be green at the start of your opening statement. The light will turn yellow when you have 1 minute remaining. Please begin to wrap up your testimony at that time. The light will turn red when your time has expired. Ms. LaFleur, you are now recognized for 5 minutes.
Thank you very much, Chairman McInerney, ranking members Walden and Upton, and members of the committee. I am Cheryl LaFleur. I'm honored to appear before you today. From 2010 through 2019, I was a commissioner and at times chairman of the Federal Energy Regulatory Commission, but I'm here today as a private citizen. I'm going to focus on two aspects of the Natural Gas Act, Section 7, that grants the authority to build pipelines, and Section 5, petitions for rate reduction. When the Natural Gas Act was passed in 1938, and for decades after that, the nation's supply of natural gas was thought to be confined to geographically constrained regions in the Southwest and the Gulf of Mexico, mostly. The purpose of the act, as demonstrated in its language and legislative history, was to make sure that limited gas got shared with other regions of the country that needed the gas. FERC, over time, established a practice of using market signals to decide whether there was need for a pipeline. If the proposed pipeline had contracts to sell the gas to people who would buy the gas, in essence, the need for the pipeline was presumed, and the Commission worked on other aspects of the application. That system seemed to work pretty well, or at least with much less controversy than today, for a very long time. In recent years, however, as the committee knows, the gas supply situation has changed dramatically. New extraction technology has allowed gas to be extracted from vast shale plays spanning multiple states in the Southwest, Midwest, and Mid-Atlantic regions. This far greater availability has made gas cheaper, a fuel for electric generation, and increasingly an export commodity. With these changes, FERC's pipeline regime, developed in a different era, has come under public attack and has been heavily debated at the Commission itself. One key issue is how the Commission determines need. I believe for some time that given the much greater availability of gas and the resultant potential for overbuilding pipelines, FERC should no longer rely simply on the existence of contracts. Instead, FERC should build a factual record on the need for the gas, the proposed end uses and the regional need, and look at multiple pipelines if they're in the same region, and that would allow FERC to balance the benefits and costs better. Another controversial issue is how FERC considers the climate impacts of pipelines. Now, gas has a complicated relationship with climate. It's an improvement over coal, heating oil, and it helps work with renewables, but on the other hand, it has its own greenhouse gases and methane emissions. In 2017, the D.C. Circuit Court of Appeals ruled that FERC was required to consider downstream greenhouse gas emissions of pipelines. How to apply that case has been the subject of considerable disagreement among the commissioners. In April 2018, FERC issued a notice of inquiry to take a comprehensive look at the pipeline process, including need, how they do environmental review, and other issues. They haven't done anything on that since, and I believe, although FERC is very busy, it's time for FERC to return to that notice of inquiry and look at those issues, because a new process that was developed hopefully in a bipartisan manner at the Commission would be fairer and more efficient than one that's dictated by court orders successively, that's done piece by piece. Secondly, on Section 5 reform, under the Natural Gas Act, if a pipeline wants to increase rates, it files a Section 4 case at FERC, and FERC sets a refund date, usually 5 months later. And once all the trial has happened and they decide what the rate is, the customers pay that new rate, usually higher, as of the refund date. But if a customer or FERC wants to reduce rates, FERC doesn't have the power under Section 5 of the Act to set a refund date. So rates aren't changed until the entire end of the case, which can be years later after discovery and trial, and then the new rate goes into effect. Because no refund date is set, pipelines have an incentive, a natural commercial incentive, to make the litigation last as long as they can, to not settle the case, to avoid cutting rates, and to discourage people from bringing Section 5 cases. This was highlighted when you all passed the Tax Cuts and Jobs Act in 2017. The Commission was able to take relatively prompt action to make sure that electric companies gave back the tax savings to their customers. But on the gas side, it was much harder and slower, and in some cases unsuccessful, to have the pipelines give back the tax cuts to their customers. So I have long believed that Congress should amend Section 5 of the Natural Gas Act to allow FERC to set a refund date. Thank you, and I look forward to your questions.
I thank the witness. Mr. McCannon, you are now recognized for 5 minutes. McMahon, excuse me.
Good morning, Chairman. Good morning, Chairman and ranking members and members of the committee. I'm Mike McMahon of Boardwalk Pipelines, and I'm testifying on behalf of the Interstate Natural Gas Association, Pipeline Association. I appreciate the opportunity to speak today and look forward to answering any questions you may have. My remarks will focus on three key elements. First, the Natural Gas Act is working. Second, modifications to Section 5 of the Natural Gas Act lead to a natural question: why now? Third, predictability and stability that the Natural Gas Act affords are critical in keeping costs low to consumers. The Natural Gas Act has been a catalyst for significant pipeline infrastructure build-out that has occurred across the United States over the last 15 years. The infrastructure development has benefited the economy by significantly decreasing the cost of natural gas paid by consumers, spurring industrial and manufacturing growth, bringing back a significant number of jobs to the country, providing an alternative source of fuel for the generation of electricity, reducing greenhouse emissions. This infrastructure has provided the reliability and flexibility necessary to partner and support increasing levels of electricity generated from renewables. All this has occurred under the current framework provided by the Natural Gas Act. With respect to modification of Section 5 of the Natural Gas Act, FERC is actively utilizing its statutory authority to review pipeline rates. As a result of the Tax Cuts and Jobs Act, FERC recently required all jurisdictional pipelines to file a cost and revenue study similar to those used by the Commission when they are conducting a Section 5 investigation. In more than 60% of those cases, FERC found there was no further need to review the pipeline's rates. In approximately 30% of those cases, pipelines either volunteered to reduce their rates, initiated their own Section 4 rate case, or filed settlements with their customer. FERC initiated Section 5 proceedings against 6 pipelines as a result of the exercise. The average unadjusted return on equity for those pipelines that elected not to modify their rates, in which the Commission found that there was no further review needed, was on average 6.5%. This process is not the only time that FERC has reviewed pipeline rates. Since 2009, the Commission has brought 25 Section 5 cases against natural gas pipelines. All but 2 of those cases have been settled or dismissed within a 6-month window, indicating that the desire by all parties to resolve Section 5 cases in an exponential manner. Finally, since 2005, our industry has spent over $110 billion in new infrastructure, which has brought low-cost natural gas to consumers and energy security to the United States. That investment has been made possible through the capital obtained in the financial markets. It is based largely on the predictability and stability of the Natural Gas Act affords. Modifications to the Act that change the predictability and stability increases cost to pipeline operators and ultimately ends up in higher rates to consumers. Looking forward, natural gas is a vital part of how we meet the country's climate goals. Congress should avoid upsetting the current balance between consumers and investors' interests provided by the Natural Gas Act's longstanding rate-making principles that continue to work in today's competitive market. I thank you, and I look forward to the opportunity to answer any of your questions.
Thank you. Mr. Wilsinger, you're now recognized for 5 minutes.
Thank you. Mr. Chairman, Ranking Member Upton, and members of the subcommittee, I appreciate this opportunity to testify before you today on behalf of the City of Wilson, North Carolina, and the American Public Gas Association. My name is Rich Wersinger, and I am the director of the municipal utility in the City of Wilson that goes by the name of Wilson Energy. Our not-for-profit distribution utility serves some 35,000 electric customers and 15,000 gas customers. We are focused on providing safe and affordable services to our customers. APGA is the National Association for the nearly 1,000 publicly owned, not-for-profit natural gas distribution systems, ultimately representing the interests of natural gas consumers. We therefore commend the subcommittee for its focus on providing the Federal Energy Regulatory Commission, or FERC, with the tools they need to protect consumers from monopoly pipelines. There exists an unnecessary disparity between the Federal Power Act and the Natural Gas Act, which have many parallel provisions to accomplish the same goal: just and reasonable rates for energy transmission. Under the Federal Power Act, if a rate complaint is filed and FERC later rules that the rates paid by the customers are unjust and unreasonable, FERC has the authority to make a just and reasonable rate effective to when the complaint case began. That means customers receive refunds, including interest, of the overcharges. This is not only fair, but tempers the tendency of the transmission provider to overcharge in the first place. FERC does not have the same authority under the Natural Gas Act. A finding that rates are too high and must be lowered can be made effective only after that determination prospectively. There is no good reason to treat these energy consumers differently. This inequity exists because Congress amended Section 206 of the Federal Power Act in 1988 to provide FERC with refund authority in electricity rate complaint cases. Congress did not pursue a mirrored change to Section 5 of the Natural Gas Act, in large part because gas pipelines then were required to have their pipeline rates reviewed every 3 years. But that requirement ended in 1992, and a subsequent fix to the Natural Gas Act has never passed. Lack of refund authority has caused billions of dollars in overcharges to natural gas consumers in all of these years. These are dollars that could have gone into local businesses in a community, or into paying food bills and mortgages, or into investing in a child's education. Instead, they have flowed upstream to the pipeline's coffers. Perhaps the best example has been the Tax Cuts and Jobs Act of 2017 that lowered the federal tax rate dramatically on corporations, including regulated natural gas pipelines. When the tax rate took effect January 1, 2018, pipeline costs went down instantly. Did consumers of interstate pipelines get lower rates at that time? No. FERC identified many pipelines that had excessive earnings, yet it took over a year for consumers to get fair rates because the Natural Gas Act Section 5 does not mirror the Federal Power Act Section 206. The issue is particularly important to public gas systems because about 95% of them, including my system, are served by just one pipeline. We must rely on FERC to determine that our monopoly pipeline is not overcharging us. But the current system allows pipelines to keep overcharges rather than refunding them to ratepayers. Of course, we support sensible new gas transmission pipeline infrastructure. This change will not affect the ability of pipelines to source capital to expand. All of the FERC commissioners that have supported this modernization certainly did not see such an impact. There are no valid reasons for this statutory inequity to continue. I thank you for this opportunity to testify and look forward to working with the subcommittee to provide this critical consumer safeguard, and both the City of Wilson and the American Public Gas Association fully support H.R. 5178. Thank you.
Thank you. Dr. Tierney, you are now recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member, and members of the subcommittee. My name is Susan Tierney from Analysis Group in Denver, and I am a former utility and environmental regulator. Much has changed in the decades since the Natural Gas Act was enacted. Americans now wholeheartedly enjoy the benefits of low-cost natural gas, and FERC's approvals of pipelines have supported that outcome. Even so, the nation's energy systems are in transition. For example, with one exception, every member of this subcommittee comes from a state with a goal to reduce greenhouse gas emissions or rely on zero carbon supply or renewable energy. And yet FERC continues to approve pipelines affecting states that anticipate much lower use of gas in the future. Over the past 2 decades, FERC has approved 487 pipelines and has rejected 2. These projects total an amount of capacity that is nearly double the all-time peak day for gas use in the United States. Over 1/3 of the approved pipelines have occurred in the last 3 years alone. My testimony reflects my review of hundreds of comments that were filed in response to FERC's notice of inquiry about the changes FERC should make in its 1999 policy statement. Stakeholders are clearly sharply divided about the views for need for change. Oil companies, gas companies, trade associations, business groups, labor unions, politicians from gas-producing states all argue that things are working fine. Others, including states' attorneys general, state regulators, politicians from states affected by pipeline projects and concerned about carbon emissions, other academics, environmental organization, libertarian think tanks, and individual citizens think FERC should change how it reviews its projects. Notably, the U.S. Supreme Court has found that the principal purpose of the Natural Gas Act is not to promote natural gas development at any cost or in any way, but rather to do so to encourage the orderly and reasonable development of the natural gas system. The NGA directs FERC to approve gas projects only if they are required for the public convenience and necessity. FERC's approach needs to be updated to reflect current conditions and to assure that the agency carries out its duties in a way that credibly satisfies the public interest purpose of the NGA. A key element of building confidence in FERC's review would be for FERC to change its near-exclusive reliance on precedent agreements as the basis for determining whether new projects are needed. When FERC reviews a pipeline application, the agency looks to see if the applicant has an agreement with someone who wants to purchase capacity on that pipeline. FERC treats such agreements as decisive in determining that a pipeline is needed. But such agreements reflect the private interests of two parties, and a precedent agreement alone cannot universally demonstrate that a pipeline project is needed to meet the public convenience and necessity. FERC's current approach undervalues the many other factors such as demand forecasts, availability of capacity in regional pipelines, impacts on landowners, and so forth, that are relevant when reviewing whether an approval of a particular pipeline serves the public interest. FERC's reviews should compare the anticipated benefits of a project against its anticipated economic and environmental costs. These are real costs with gas pipelines that are not reflected in the prices paid by parties who use and benefit from the project. As an economic regulator, FERC should use a more fulsome need analysis that relies on a more fulsome and systematic benefit-cost framework. FERC's over-reliance on precedent agreements is especially problematic in cases where pipeline developers use eminent domain to take land for their projects. Taking land cannot be for the purpose of serving private interests. FERC should give great weight to the interests of landowners, and FERC should give great weight to the the views of states that especially will be impacted in one way or another by the pipelines that go through them. Finally, FERC should consider both the direct and indirect environmental impacts associated with the gas that is transported across the pipelines. Other agencies that review bridges look at the impacts of vehicles on the bridges. FERC should do the same for its pipelines as well and review the impacts of gas. Finally, FERC should quantify and monetize greenhouse gas emissions impacts wherever reasonably feasible to do so. Emissions introduce greenhouse gas, serious climate impacts on public health, infrastructure, and economic activity. Thank you very much.
We have now concluded opening remarks. We will move to member questions. Each member will have 5 minutes to ask questions of our witnesses. I start by recognizing myself for 5 minutes. Commissioner LaFleur, you were an early proponent of Section 5 refund reform, writing back in 2010 a concurrence that you support legislative action to amend the Natural Gas Act to align it with the Federal Power Act. Could you talk a little bit more about your experience with the Tax Cut and Job Act and the difference between FERC providing refunds under the Federal Power Act versus process under the Natural Gas Act?
Yes, thank you, Mr. Congressman. When the tax cut was passed, FERC looked at the electric companies, the transmission companies that are covered by the Federal Power Act, and they all either had formula rates where the tax rates immediately, or the next time they did their formula, automatically went down to customers, or if they had stated rates, FERC promptly filed Section 206s to require them to recompute their stated rates for the lower taxes. With the pipeline companies, it's extremely a long, slow process to file a 205. FERC did not have the resources to file a Section 205 against the several hundred pipelines it regulates. And also, so FERC came up with a process where we made up a new form, Section 501, that required the pipelines to report in what their revenues would be with the new tax law in effect. And staff took several months to go through all of those forms and figure out which ones were most over-earning, and then as to those, had to start Section 205. So because of all that, it took actually more than a year, some time before the 30% that actually reduced their rates. And had there been the refund authority, I think FERC could have much more promptly delivered those savings to customers.
Thank you. Ms. Tierney, or Dr. Tierney, you noted in your testimony that FERC could rely on a cost-benefit analysis to determine project need. You also note that doing so would better align FERC with responsibilities under the Natural Gas Act. Could you explain the basic framework behind this analysis and how it would be well-suited?
Sure. Under the Natural Gas Act, again, which has a public interest test, FERC today only relies on precedent agreements. FERC could identify, through a review of the opportunities and benefits associated with providing natural gas into a market. This is the kind of review that FERC and states do routinely when they are looking at new facilities. Additionally, FERC could look at the dollar costs associated with infrastructure investment, other economic impacts in the areas that are going to be served by the pipeline, as well as the environmental impacts. And balancing both those environmental impacts and economic benefits and costs would be a great improvement over today.
So how exactly does the precedent agreement rule work? It's not a rule, but how does that work these days?
A precedent agreement is an indication that a customer has an intention to purchase gas transportation service on a pipeline. The pipeline relies upon that as part of its application to FERC for a certificate of public convenience and necessity, which is an approval of the pipeline. Although FERC has, in its 1999 policy statement, said that it would rely on a lot of relevant factors, gas demand, other pipeline capacity, and so forth, if there is a precedent agreement in place, FERC in effect checks the box that the project is needed. And there are instances where there are affiliated companies who are both the buyer and the seller of gas who are putting those precedent agreements in place, and they are particularly instances where FERC should be doing a more fulsome review of the project's public interest benefits and cost.
Thank you. Again, Commissioner LaFleur, can you speak to the importance of jointly considering the impacts of multiple proposed pipelines for the same region?
Yes, and I think a good example of this is the Atlantic Coast and Mountain Valley pipelines, which are both going through very, very similar routes with a similar start point across the West Virginia and North Carolina. I think there's a concern that if pipelines are considered seriatim, just looking at whether someone has, including, as Dr. Tierney said, an affiliate, someone has signed up to buy the gas, you could result in a situation where two pipelines, in these cases very large pipelines, are sited right near each other, but they both, if you look at them in a vacuum, look like they're needed. But when you look collectively at how much gas the state of North Carolina or wherever is going to need, you can see that they could have much more readily been combined into one pipeline. Under the National Environmental Policy Act, you're supposed to look at alternatives, and I think FERC should look more holistically at whether there are better alternatives in building every single pipeline that comes along.
Thank you. The chair's time has expired. The chair now recognizes the ranking member of the subcommittee for his 5 minutes.
Thank you again, Mr. Chairman. So, Mr. Wisner, Mr. McMahon, a question for you. So, what percentage of a consumer's bill is the transmission charge in the pipeline, of the pipeline cost, versus the rest of the rate that they may pay, usually on a monthly basis? Is it transmission charge with it to actually transfer that energy on the pipeline, is that right?
In my testimony, Congressman, I put a chart in there that said EIA estimated at 12% in this current low price environment.
So is that about the right standard in North Carolina? Is that about what it is?
Well, first, you're asking me to estimate something I don't have exact facts for, but I would suggest it's more than 12%, maybe closer to 25%. But it certainly is significant.
Yeah, because I just know we have a lot of natural gas in Michigan, and I know that when the tax cut bill passed a few years ago, at least in Michigan, it was almost, within a couple of months, there was a reduction to consumers across the board that went through the State Regulatory Commission approval, but I didn't ask them the timing or the percentage in advance of the hearing. Mr. McMahon, how does FERC establish the pipeline rates to make sure that they are, quote, just and reasonable, the term that all of us have used, that natural gas...
When a pipeline files a rate case, it presents all of its costs. So you're going to have the cost to operate and maintain are part of the cost to kind of do the back office. Currently there's costs for cyber. So all the costs, including your taxes, property taxes, all that are added up. And then what happens is then you look at your throughput, and then you basically divide your cost over throughput. And as a result of that, you get a per unit rate. So let's say you have $1,000 and 100 units, you'd have a $10 rate. So that's the rate that would be established, assuming that there's one maximum applicable rate. Then that would be the rate you could charge. So you have your cost, your return, all that, then divided by throughput equals the rate. That's kind of a simple way of thinking about it.
And there is a public process, is that right, where
Yes.
consumers can weigh in?
Yes. When a pipeline files its rate case, it gives notice to all of its customers. So all the customers have the ability to participate in that proceeding. You have, in certain regions of the country, you have the state utility commissions participating or state advocates participating. And then you have FERC staff who participates in the litigated proceeding in more and more as a consumer protection agency type of advocate.
Now, I know that, if we look really after the last 15 years, 20 years, fracking, et cetera, we've got the abundance, we now can export it, which we couldn't do it before. We've sped up that process through bipartisan legislation that President Obama signed into law. And I know as it relates to Michigan, and I think you cited this, I still say Commissioner LaFleur.
That's okay.
We have a renewable percentage that we're going to exceed, and it's going to continue to get better, which is good. We're phasing out coal in Michigan, and natural gas is coming in big time. In fact, I worked on some permitting process that was allowing a new company in one of my small towns, 8 traffic lights, $1.1 billion new facility that'll be online in about a year. It's incredible, 600 people working to put this up. Obviously, it's going to be cleaner. It's going to be replacing coal. Sadly, we've got a nuclear plant that's closing down, but it'll pitch in for that to a degree. But where I'm getting to is a number of companies in communities, because they're seeing supply and demand. There's more supply, demand is still growing, but the costs are coming down. So a number of utilities are now asking consumers to actually lock in at a rate that's lower per therm than it has been over the last couple of years. And again, they're working through the Public Service commissions, that's what they call it in Michigan. So it seems as though the process is working and the costs are significantly less, whether it be farmers or others. I guess I'm finishing with a statement instead of a question. It's my time. We have a new chairman who's being rough on me, so anyway, yield back.
Thank you, Mr. Upton. I'll ask a question, but first I want to say, I think it would be hard to argue that the proliferation of natural gas displacing coal hasn't been good from an environmental perspective, if for no other reason than getting rid of the metals that are polluting the atmosphere. And I do think that, you know, people claim credit for, as a result of that, for lower carbon emissions. But what we don't talk about is methane. And actually, one of the most damaging climate change agents are these short-lived climate pollutants, including methane. So I want to ask Ms. LaFleur and Dr. Tierney is whether you believe that under the Natural Gas Act, considering the ruling in 2017, is it within the jurisdiction of FERC to regulate methane as a condition of permit approval?
FERC, thank you for the question. FERC has the authority to consider methane, and in fact, the methane leaks, I know that's not a word everyone likes, but the methane emissions from pipelines are considered a direct environmental effect of the pipeline, and they are carefully toted up in the environmental impact statement. So that's not the part that's in dispute, which is the greenhouse gases at the end. FERC doesn't, however, and FERC can place conditions on the construction to make sure that the construction limits methane emissions. But long-term safety regulation is in the jurisdiction of PHMSA, the Pipeline and Hazardous Materials Safety Administration. So FERC doesn't regulate methane once the pipeline goes into service.
Dr. Tierney?
I'm not a lawyer, so I'm just going to respectfully refrain from making a legal opinion about what FERC is authorized to do. But I could observe that when other federal agencies, such as the Department of Transportation, is looking at the environmental impacts of using a road or a bridge, they use the emissions associated with vehicles going across that bridge. You could imagine that FERC could use a similar approach when it is looking at the indirect emissions associated with the gas that is transported.
Right.
There are methane emissions associated with producing gas and consuming gas, and those ought to be taken
There's
into
methane emissions at production, at transmission, and at distribute or delivery, I
use.
suppose.
Yes.
So I suppose that's true. What I'm trying to get at here is you know, it seems clear that you can consider the impacts of methane as you discuss a pipeline, but you don't have the authority to say, listen, as a condition of this approval, we want you to use better equipment, better pumps and we want you to monitor methane. Is my impression, Commissioner? Is that what you believe?
I believe we have, FERC, not we, but FERC has the authority to set rules on the construction of methane, and I guess FERC could say
Construction of pipeline.
this pipeline is not in the construction of the pipeline and how much methane they release, and FERC could say we don't find this in the public interest because you don't have enough methane control, come back with a better plan.
Okay.
But FERC can't directly regulate the operation once it.
This is the thing that concerns me. It strikes me we're asking FERC to do macro regulation, macro policy at a micro level, pipeline by pipeline. But to me, and I think that's the most important thing, if you want to make any deal with natural gas as a bridge fuel, a so-called bridge fuel, we have to deal with methane. And so maybe, Mr. McMahon, I'd leave it to you. What do you think the industry can do to make sure that we're not emitting methane, and how do you think it should be monitored, and how do you think it should be controlled?
Well, the industry is fully committed to reducing methane emissions, and one of the things that we've undertaken over the last several years is reviewing of all of our operations. You know, what equipment do we have, especially in compressor stations, that can be updated or modernized? Where are the potentials for leaks? Enhancing our testing and using different technologies to test for leaks. The other thing almost every pipeline I'm aware of is very much concerned about is what is called lost and unaccounted for. That gas which just you can't find, and where that's coming out.
I only have 30 seconds. Let me just say, the price of natural gas is cheap. That's why it doesn't regulate itself. I mean, I just don't believe this notion that Lost gas is a huge loss to the industry. It's not like gold. So here's my suggestion. If the industry's serious about it, we'd love your help with the Super Pollutants Act, which would impose monitoring and emission regulations on new sources and existing methane sources. We'd love to work with you on that, because I think, to me, that's the biggest problem I have with natural gas right now. And my time has expired. I'll now recognize the gentleman from Ohio, Mr. Latta.
Well, thank you, Mr. Chairman, and thanks for holding today's very important hearing, and also thanks to our witnesses for being with us today. By 2040, global energy demand is expected to grow by 28%. The market in India alone is valued at $2.7 trillion by 2040. If the United States is to play a role in meeting future global energy demand, our nation must develop increasingly advanced technologies that will outcompete our rival nations. A homegrown U.S. advanced energy economy will shape and even lead such a market, furthering our energy security, geopolitical influence, and economic opportunities abroad. I recognize the importance of these opportunities when I introduce House Res 597, which calls the United States to support and not limit access to all domestic energy resources in an effort to achieve full energy security. As we build out our technology, significant new infrastructure will be needed to meet the challenges like new gas pipelines, CO2 pipelines, and also high voltage pipelines. If I could start, Mr. McMahon, with you. In your testimony, you speak about the substantial benefits that have resulted from the growth in natural gas development and the wider energy renaissance in our country. Would you go into more detail about what you have seen and how companies have reinvested in their communities as a result of the growth?
Yes, in one of the areas that we operate along the Gulf Coast, as you see, a true resurgence in the manufacturing process, and where natural gas is being used as a feedstock. The big companies have associated there, the job growth that has occurred in those areas. I know that in recent years in the Marcellus and Utica areas, which are in your home state as well, you're seeing people moving projects and industries that typically are found on the Gulf Coast in to take advantage of those resources. So what we've seen is a resurgence of the manufacturing chemical that used to be done offshore because people were using crude oil to crack to make those products, are now using the natural gas and the natural gas products, and they're moving them out of the Gulf Coast into more local areas, and you're seeing tremendous job growth in those areas.
Well, that's very important, because in my congressional district, I have 60,000 manufacturing jobs, and I mean, we make everything. So when you're thinking about from steel to float glass, and you go right down the line to very small companies that are out there manufacturing, and also not only manufacturing for something in this country, but also for export. And I think it's important that as you look at that, because of those multiple reasons why companies look to, come into an area, they look at things like, what's out there. And one of the things that I know when I've talked to the hundreds and hundreds of companies I've visited in very short periods of time over the last several years, cost of energy always is at the top of their list. And then also the availability into the future of that energy. And so when you're looking at that, how are we going to make sure that when someone's looking at an area that we can say that they have that energy, that they have it into the future? Because again, I think what you said, that you're bringing it from different parts of the country to other areas. How important is it then for companies to make sure that they have that energy locally?
Well, that's where we work with our customers to make sure that we bring natural gas to the communities and to the areas. That's the reason you've seen such an expansion of the interstate pipeline system, where it used to primarily move gas from the south to the north. It's now moving gas east-west, north-south, and south-north. So we have been moving pipeline to attach to new manufacturing and new demand centers as they grow. And so the Natural Gas Act has given us the flexibility to meet the changing needs and location of manufacturing and production.
Thank you. Dr. Tierney, how can FERC and other federal agencies better support this infrastructure build-out, and how can these agencies better coordinate with state and local entities?
Well, To begin with, as I mentioned in my original statement, I believe that FERC should do a better job of taking into consideration state objectives. Many states are quite interested in developing their gas resources. Others are interested in reducing reliance on natural gas. Those considerations, I believe, are things that FERC should be looking at when it's considering whether a project is needed. But I also think, in light of the comment that you made earlier about the important global trends that are going on in energy use, one can think about the role of U.S. manufacturing and U.S. Production and innovation in selling products to those other nations that don't rely on importing things like gas or oil over time, but then can use renewable resources in those locations as well.
Well, thank you very much, Mr. Chairman. My time's expired, and I yield back.
Thank you. The chair now recognizes the gentleman from Iowa, Mr. Loebsack, for 5 minutes.
Thank you, Mr. Chair. I want to thank Chairman Rush and Ranking Member Upton for holding this hearing today, and I want to thank you to the witnesses, big thank you to the witnesses for being here as well. I really appreciate this. Although Iowa does not produce any natural gas accounts for over 1/5 of the total energy consumed in our state, and nearly 60% of the natural gas delivered in Iowa is consumed in the industrial sector and plays a critical role in supporting also the production of clean burning biofuels. So we use natural gas to help produce ethanol and what have you, which are also a key economic driver in our rural communities, as you know. Additionally, over half of Iowa residents use natural gas as their primary heating fuel to heat their homes. Iowans regularly face, as you know, some of the harshest winters, although this winter hasn't been so bad, so my costs haven't been quite so high. But it's absolutely critical that folks who rely on natural gas to heat their homes are not facing unnecessarily high costs when they're doing so. We've heard from several witnesses today regarding how modernizing Section 5 of the Natural Gas Act to allow for refund authority in line with what already exists under the Federal Power Act could help put more power in the hands of natural gas consumers, which is something I think a lot of us are interested in doing. And when it comes to fighting for just and reasonable rates, and I know my colleague, Mr. Butterfield, has recently introduced bipartisan legislation on this issue as well. So I want to start out, Commissioner LaFleur, I'd like to start with you. Do you agree with Mr. McMahon's, and I'll get to you, Mr. McMahon, when this is over, so tell me if I'm misrepresenting you. But do you agree with Mr. McMahon's testimony on why Section 5 is fair as it is? Specifically, he argues that because pipelines have negotiated rates, there's no need for Section 5 reform, and that any potential rate reductions would not flow to consumers. So just if you would comment on that.
No, I respectfully disagree. First of all, when FERC does use its Section 5 authority, FERC looks closely at what percentage of the pipelines is on negotiated versus stated rates. And it is certainly true that there are pipelines with a lot of negotiated rates where this doesn't matter. But people like Mr. Warsinger's customers and public gas and other customers of gas distribution companies often pay the stated rate. And so it would matter to them to have the Section 5 reform. Also, at least I used to run a gas distribution company, although a long time ago, and as Congressman Upton said earlier, the state regulators make you give back the money if you pay more or less to the pipeline companies. Maybe not that same day, but the next time you have a rate case, which is required on a regular basis, the state distribution companies would be required to reduce their rates because they're regulated in Des Moines or all of the state capitals.
Okay. Yeah, and I'd like to go to you, Mr. Warsinger, then, if you'd like to respond.
Yes, thank you, Congressman. I think the best way to talk about this is refer to the Tax Cuts and Job Act of 2017. I have the honor of not only overseeing the City of Wilson's gas system, but I also look after their electric system. With our electric system, our electric wholesale provider had their costs reduced by the Tax Cuts and Job Act. They lowered our rates effective January 1, 2018. We immediately got the results of those lower costs. Our gas transmission pipeline took over a year for them to reduce rates, and they did not do a refund because they didn't have to. And that not only affected the City of Wilson, there are actually 8 municipally owned gas systems in the state of North Carolina, all served by that one pipeline, who did not get the reduced rates for over a year. And what happened to that money that was, the costs were reduced, the pipelines kept it.
Right. Mr. McMahon, would you like to respond?
Yes. There's a couple points. To be clear, I would agree with Commissioner LaFleur that if somebody's paying the stated rate and the stated rate goes down, they get a benefit. But over 60 or closer to 70% of most pipelines now are people who are not paying the stated rate. So they wouldn't, unless the rate fell below their contract levels, they would not get a benefit. There would be nothing to refund to those customers. So I want to be clear on that. There's been both, Mr. Warsinger and Commissioner LaFleur have mentioned the frustration about the tax cut. But I'd like to remind the committee that FERC has had a long-standing policy when it comes to pipeline rates and not allowing single-issue rate adjustments. So if the rates had gone up, we wouldn't have been able to go in, excuse me, and ask just for a price increase because our taxes went up. Right. We'd have to file a full-blown Section 4 case. This is different than the electrics, who, as Commissioner LaFleur said, are on some type of index-based or formula rates.
Right. I did have a question connected to that, but I ran out of time, and I'll yield back now. Thank you, all of you.
Thank you. The chair now recognizes the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chair, and thanks to the panel for being here. The state of Michigan has one of the largest natural gas deposits in the entire nation. We're thankful for that, with almost 1.1 trillion cubic feet of underground natural gas storage. As harsh winters affect my state, natural gas and its ability to be stored in our underground capacity make energy demand a lot easier to plan for. It's no surprise that more than 75% of households rely on natural gas, my own included, to heat their homes in Michigan. Combined with its low environmental impact and its strong reliability, natural gas is a great alternative for powering our country. There's no question the impact that natural gas has had on the everyday lives of Michiganders and our state's economy. As decisions related to the future of the energy grid of the nation are considered, policies looking to further increase production and expansion of natural gas infrastructure are critical. And so, Mr. McMahon, it seems that some of the policies in the Clean Future Act offered by my colleagues on the other side might lead to a decrease in new pipeline infrastructure. Do you think that instead we should be encouraging oil and gas production and construction of new natural gas pipelines in this country?
I think that the natural gas pipeline industry plays an important role in the growing economy of this country and the providing of jobs. As you've seen over the last 15 years, we've been allowed to build pipelines, and then that has spurred the economy. As more natural gas is produced, there are markets, in foreign countries where I think LNG would be a great benefit to the global climate concerns. And I think continued production of natural gas will keep the cost low to consumers, increase the availability of manufacturing for the manufacturing sector, especially since gas serves both as a fuel and a feedstock in a number of processes.
Which certainly means we need a growing labor force in that area as well. And so, my constituents include many skilled trade workers employed by the energy industry all across the district. Can you discuss the type of jobs that the natural gas pipeline industry provides for employees and contractors, and the type of jobs and numbers of jobs that are needed at this point in time?
Well, on the construction side is when a pipeline is being built, is if you think of a single construction spread of somewhere around 30 miles of pipeline, those typically employ 500 skilled laborers, ranging anywhere from equipment operators to welders to other type of skilled. And those are good paying, jobs with good benefits. The industry itself, while as we've become less employee intense out in the field, where we do have field operations, again, those are good paying jobs with good benefits. But as we start building infrastructure, if you're building a big pipeline, you may have 2,000 to 3,000 people employed at any given time working on that pipeline. And then obviously in the communities where the pipeline's being built, they're getting the benefit of kind of an uplift in sales of all the employees in those areas.
It was interesting to see some major construction of pipelines going through my district, a couple large ones, and the numbers of employees, the level of pay and wages that were there with benefits, and the extent of the time period that they were employed on those pipelines gave an encouragement to be able to talk with younger people and say, if you're looking for a career, there's all sorts of options there. So we want to see that continue. Thank you, Mr. Chairman. I yield back.
Thank you. The chair now recognizes the gentleman from Massachusetts, Mr. Kennedy, for 5 minutes.
Thank you, Mr. Chairman. I want to thank Chairman Rush and Ranking Member Upton for convening this hearing, and I thank our witnesses for testifying in your presence here. Today in the United States, nearly 80% of Black Americans live within 30 miles of a coal plant, breathing in toxic chemicals and living with health consequences of our deference to fossil fuels. More than 80% of Latinos live in American counties where at least one federal air pollution law has been violated. In cities across our country, low-income communities suffer from extreme heat zones and a lack of tree canopy and air conditioning, raising the risks of asthma, heart disease for people already living in areas with limited access to quality, affordable health care. Now, I know we're here today to discuss modernizing their natural gas infrastructure, but I don't believe we can effectively do that without acknowledging fundamental flaws in our nation's energy policies. Because far too often our system rewards industry interests at the expense of public interest and American lives. We are well aware of the need of a comprehensive approach for climate change, but by no means can we simply ignore the climate risks that we ask ratepayers and communities to continue to pay ask them to continue to pay for the consequences. So, Commissioner LaFleur, broadly speaking, is FERC required to consider environmental effects of a proposed infrastructure project during its public interest consideration?
Yes, I believe so. First of all, FERC has to consider the environmental impacts when it does the environmental review under the National Environmental Policy Act, but it's also a key part of balancing the costs and benefits to determine the public interest. And I believe the law already allows that the public interest can include climate impacts. That's what the D.C. Circuit said.
Do you believe that FERC must consider the environmental impact then when improving a natural gas project, to be more specific?
Yes.
So I'm concerned, Madam Chair, one of your former colleagues recently wrote in a concurring opinion that he, quote, respectfully disagrees with the Supreme Court's finding, quote, that FERC is required to consider environmental effects during its approval process. Would you agree with that statement?
No, I disagree on two counts. First of all, my reading of the law is that the public interest standard is robust enough to allow FERC to consider things that were not known in 1938, like climate impact. Other things that were not known in 1938 are certainly considered.
Is FERC free to disregard
I
Supreme
also don't
Court
think
decisions?
FERC can gainsay what the courts say. Yeah, I'm sorry.
I was interested in understanding whether that FERC can ignore a Supreme Court finding.
FERC has to follow what the courts tell it.
And is that then, if I can ask, given the articulation of one of your former colleagues, how am I supposed to interpret that?
I think he has an honest disagreement of belief of how he reads the Natural Gas Act, which is why there's a process for appealing from FERC, and courts can tell FERC they did it wrong, as the Sierra Club case, the Sable Trail case said, and several other recent cases.
Okay, so does the Natural Gas Act need to be amended to clarify a public interest determination to include a consideration of all environmental impacts, including climate change?
I think that would be an excellent addition to the law, because I think a recent statement of congressional intent is always extremely valuable, but I think I wouldn't want anyone to argue, if it didn't pass, that that wasn't already in there, because public interest is a very broad standard.
Given that it is a broad standard, Commissioner, that kind of leads to my next question. Climate change is an issue that has gotten rather politicized over the course of the past several years, given the fact that it's a broad standard. Do you think specifying and laying out some details to consider with that standard would be helpful or hurtful?
Yes, I think the more clarity is, there's less room. FERC is a creature of statute, and the clearer the statutes are, the less room there is for FERC the less wiggle room to misinterpret the statute.
And when it comes to the issue of pipeline siting, do you believe that that issue has become politicized within the agency?
I think there's been just a lot of partisan voting at FERC, unfortunately, over the last several years. I was a part of that. It takes two sides to be partisan, so I'm not pointing fingers at anyone. But there's just big disagreements about climate change and the future of the generation mix, and this issue is one of them.
Ms. Tierney, and then back to you afterwards, Commissioner, if I have time. Could FERC adapt and apply a metric like a social cost of carbon to significance determination on greenhouse gas emissions under NEPA?
I certainly think FERC has the authority to do that. Again, I'm not a lawyer, but there are ways to monetize these impacts on infrastructure, on people, and that's what the social cost of carbon does.
And what's
So,
impeding
yes,
FERC from doing so?
different interpretations about the importance of doing that.
Okay, yield back. Thank you.
Gentleman's time has expired. The chair now recognizes the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. West Virginia has really been impacted in the last few decades with the exploration with the Marcellus, Utica, and eventually the Rogerville. So we're keen on this, what's happening in the Mid-Atlantic area as we try to get more gas out of the ground and try to move it around. So, but we're concerned about is the infrastructure. And very concerned about the impact this legislation could have on the infrastructure, because EIA came out with they had their report, and one of the items that they brought about their attention and focus was on the cost of the gas to the consumer. One of the 6 major things was the availability and the capacity of transmission pipelines to move natural gas from producing areas, storage facilities, and trading hubs to distribution. We have a problem with this, and that here it is in West Virginia with all that gas, but yet we're in the middle of the run of the cost across this country and gas rates. So we've got to find this. If that's accurate, we've got to find a way to build transmission pipelines, and I'm concerned that through this legislation we're going to see a reduction of that, and that's ultimately going to hurt manufacturing and consumers with it. I mean, there have been billions of dollars invested in the Mid-Atlantic area. I think, according to my statistic, 124,000 jobs have been created with it. All that investment is also helping out those counties to help out on schools, first responders, healthcare, on and on and on. So I'm really concerned whether or not this legislation, the impact it could have on it, what it's going to slow things down. This is a chance for an economic recovery in the Mid-Atlantic and the Appalachian area. And we're seeing people try to stop it using, they're fighting the Commerce Clause of the Constitution, that preventing us from having pipelines across state lines. I think that ultimately will be played out with it. So if we're trying to prevent this inhibiting effect that this legislation have, Mr. McMahon, if I could focus in on you just a little bit, what's your opinion? Do you think that this could jeopardize the economic development in the Mid-Atlantic and those producing areas of the natural gas?
You know, as I said in my opening statement, the thing that pipelines really need is stability and predictability. Is if we know what the rules are, we're going to abide by the rules. And to get a project built, as you're aware, it takes time. So it takes about a year before you ever get to FERC and then the FERC process. So if midstream the rules change, you're going to have projects that are hung up because the rules have changed and they didn't get it. So that's the reason we keep saying that the Natural Gas Act has worked well. It's not broken. It doesn't preclude, as the courts are telling us, what we should and shouldn't do, certain reviews. I think that the more restrictive you make it, the more concern you rightfully have that it's going to inhibit or slow down the build-out of necessary infrastructure.
Let me build up a little bit. I'm going to switch gears with you just a little bit, because in the Mid-Atlantic area, in this Appalachian and West Virginia area, we've been producing quite a bit of natural gas liquids, ethane and like. The question here would be, if these are the feedstocks for petrochemical manufacturing and could diversify the economy in West Virginia, Eastern Ohio, parts of Pennsylvania, Virginia, if we could have a storage hub of these products there, so that a secondary hub that we have comparable to what's going on in the Houston market. So instead of the liability, the exposure we have, that storage hub with these ethane stored in West Virginia, do you have an opinion about that, about the possibility of having a second petrochemical, not competing, but just a secondary hub?
Well, on the liquid side, that's kind of outside Inga's kind of bailiwick, since we're kind of natural gas transmission operators. But, you know, the development of hubs and pricing centers for either natural gas or natural gas liquids, I think is beneficial to the entirety of the industry.
Okay. Mr. Chairman, I yield back the balance of my time.
Thank you. The chair now recognizes the gentleman from Pennsylvania, Mr. Doyle, for 5 minutes.
Thank you, Mr. Chairman. I want to thank the chair and ranking member Upton for holding this hearing. Natural gas is a vital fuel for our economy. It's essential to keeping the lights on all over the country. And in western Pennsylvania, it has been a tremendous economic driver, providing good-paying jobs and cheap energy that helps businesses grow. It also has helped lower carbon emissions from the power sector, as it has replaced coal as the main power source in many parts of the country. Unlike in western Pennsylvania, most places do not have abundant natural gas reserves. They need pipelines to get the gas, and the build-out of pipeline infrastructure is vital to providing cheap natural gas around the country. However, we must make sure that we strike the right balance between developing this vital infrastructure and ensuring that landowner rights are not being trampled, and that we're accounting for climate change and that ratepayers are not being overcharged. Mr. Warsinger, you mentioned that 95% of APGA members are captive to a single interstate natural gas pipeline. How does this weigh on a natural gas customer's decision to file a Section 5 complaint against one pipeline if it needs against the one pipeline it needs to get its gas from?
The cost to bring forth a Section 5 filing is very expensive. Something that most of APGA's members would not be able to afford. It would far exceed probably their annual gas transmission costs for a couple of years. So it's not likely that they would do that. But let me just add, we support the construction of the Atlantic Coast Pipeline. That's going to bring the gas from your area down to our area in eastern North Carolina, where we desperately need it. Mm-hmm. One of the other congressmen mentioned about having a float glass plant in his area. There was one that was considering eastern North Carolina. Unfortunately, we did not have the natural gas capacity for that plant, and that plant ended up being constructed in Canada. We need these pipelines for that.
Thank you. Commissioner LaFleur, if Congress were to reform the Natural Gas Act to include refund authority, do we also need to look at conforming changes to Section 4 of the National Gas Act? And do you believe that giving FERC refund authority alone would suppress the incentive to build the needed pipelines?
I'm not aware of any mirroring changes that need to be made in Section 4, because there already is a robust refund authority. And I don't believe on the electric side in Section 206, where there's been refund authority for a long time, that has suppressed the development of the transmission industry. I think, as Mr. McMahon's testified, a lot of customers are on negotiated rates. It would clearly have an impact, but it would be a new, secure, stable regime, different one than they have now.
Thank you. Dr. Tierney, could you provide us some more detail on what you believe FERC should consider? You said in your written testimony, FERC should expand its determination of significant versus non-significant impacts and broaden its definition and consideration of project alternatives while doing its NEPA assessments. Can you just expand on that a little bit?
Sure, I'd be happy to. I would just focus on two things. One of them is that FERC does not spend sufficient attention on no pipeline alternatives. Excuse me, a no alternative. Excuse me, I'm really sorry. No pipeline as an alternative to the proposed pipeline. I really apologize. And as Commissioner LaFleur said, there are instances where there is underutilized capacity in a region that could be taken advantage of. And as you said, in a balancing test of whether or not you actually could use today's infrastructure without the environmental impacts, that would be a great thing that FERC could do. Let me stop there because I know you have limited time.
Yeah, Mr. Chairman, I thank you, and I'll yield back.
Gentleman yields. Now, Chair now recognizes the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you very much, Mr. Chairman. What I would like to do first is ask for unanimous consent to submit a letter for the record from Mrs. Irene Leach of Elliston, Virginia, that was sent yesterday to the chairman and the ranking member of this committee and subcommittee.
Without objection, so ordered.
All right, I appreciate that. In that letter, Ms. Leach, who I've known for many years, expresses frustration about landowner rights, and because co-location wasn't looked at, and maybe it wouldn't have helped her on one of them, but she currently lives in the pathway or near the pathway of the Mountain Valley Pipeline with a family farm that's been in the family for over 100 years in the pathway of the Atlantic Coast Pipeline. And this is a problem, and she extols, I encourage you all to read the letter, she extols the problems that her family has had and their concerns. On top of that, I've heard from numerous constituents, but most importantly, and refresh the committee's mind, they've heard this before, and Ms. LaFleur, you've probably heard it before too, but when Mountain Valley first came to the area, I learned about it when a member of the Board of Supervisors in one of the affected counties called me and said, Morgan, there are surveyors all over the county saying that there's some kind of a gas pipeline coming through. What do you know? The local folks didn't know anything. I didn't know anything. This has got to change. Landowners' rights have to be respected. And accordingly, I will tell you that, this brought a number of us together. After not receiving an additional hearing, FERC turned us down for an additional hearing. I sent it to the chairman. Ms. LaFleur, you were not chairman at that time. Yeah. But I sent several requests to the chairman along with then Congressmen Goodlatte and Hurt to do an additional hearing, not to change the decision per se, but the landowners felt they weren't being heard. One additional hearing in Virginia, 2 would have been great, but we would have accepted 1. We got nothing. So when you can't go to your local officials, you can't go to your state officials, and you can't go to your federal officials and feel like you're ever being heard, reforms do need to happen. Accordingly, Tim Kaine and I introduced similar, not identical, but similar legislation in the House and the Senate. Whenever you can bring Tim Kaine from his side of the political spectrum and Morgan Griffith from my side of the political spectrum together, you've done something. I'm not sure it's a good something, but you've done something. And my bill is H.R. 173. And it amends the Natural Gas Act to create greater transparency and additional public input. It requires FERC to hold public meetings in each county in which the project will be located and restates U.S. federal policy that the taking of property through eminent domain be limited in situations in which the taking is for public, not private, use, which is modeled after a George W. Bush executive order. It also requires the taking of land under conservation easement be given compensation for the lost conservation value of the land. Mr. McMahon, last week FERC announced a reorganization and new division dedicated to addressing landowner issues. Obviously, they've started to hear after 5 or 6 years of haranguing. Do you support FERC's actions to process filings by affected landowners more quickly?
I do.
And you want it to be simpler, correct?
Yes, I think that it's a good thing that they address those issues quicker. I think where it gets complex is, from going back, my predictability and stability is if you've got landowner issues that are getting resolved before the environmental issues, you still don't know what the final outcome is going to be unless they're both kind of done on the same course.
And I appreciate that. I mean, clearly landowners need to feel like they're at least being heard and some of their concerns are being addressed. And when you get a blank stare or no answer for a long period of time, that does not help the landowner. Are there other steps that FERC or Congress could take to improve the process to further address landowner concerns? And I'll raise that for anybody who wants to address it. Start with you, Mr. McMahon, and then Ms. LaFleur.
I think one of the things is the industry is evolving, and we still have to get better. We can't say anything but that. But what we're trying to do is, the last thing I know from our perspective is somebody like you hearing about a project from the first time from somebody other than us. That's one of the big changes we're trying to make, is get more transparent with local and state of.
I'm going to switch gears because I've just got a little bit of time. Ms. LaFleur, At some point, we have to decide if we're going to do co-location. We have to decide who makes that decision. Does that belong to FERC or does that belong to somebody else?
I think it belongs to FERC under the Natural Gas Act, and I dissented on the Mountain Valley and ACP pipelines because they were so close en route. I think the step FERC took last week is a good step, assuming they follow through. It basically just does the rehearings faster so landowners can appeal, but I think there's a lot more that has to be done to make sure that the construction permits and eminent domain is sequenced to protect landowner rights.
Gentleman's time has expired. The chair now recognizes the gentleman from Maryland, Mr. Sarbanes, for 5 minutes.
Thank you, Mr. Chairman. Thank you to the panel. I want to ask some questions about Section 401 of the Clean Water Act, which empowers states and authorized tribes to issue water quality certifications that must be included within certain federal permits and licenses, like natural gas pipeline projects. As you know, the Supreme Court upheld that this power is, quote, essential in the scheme to preserve state authority to address the broad range of pollution that threatens our nation's waters. Commissioner LaFleur, do you think Section 401 is an important part of the pipeline permitting process?
Yes, when FERC issues a certificate, there's usually numerous conditions that are attached to what the pipeline has to do, and one of them is get state water quality. Almost always, in either a hydro or a pipeline case, there's almost always a state water quality certificate required.
Thank
Sometimes
you.
numerous.
Right, and that's very important. In the recent Hoopa Valley case, the D.C. Circuit struck down the common industry practice of withdraw and resubmit, which is a method used to annually reset the one-year time period for states to act. The case didn't delve into the scope of states' conditioning authority, but it did interpret a one-year maximum time period for a state to decide on water quality certification application. Again, Commissioner LaFleur, while the court case concerned a hydroelectric project, do you think the Hoopa Valley decision has implications on gas pipelines as well?
Yes. After the Hoopa Valley case, which found that FERC was arbitrary and capricious for not finding a waiver in that case, FERC unanimously, all four commissioners, ruled that the state of New York had waived its authority in the Constitution pipeline. And we looked closely, I looked closely at Hoopa Valley to find any loophole that we wouldn't have to say that New York waived, but the court was pretty clear that that 1 year filing and refiling was not kosher.
Yeah, I have some concerns about where that leaves us because in addition to the Hoopa Valley decision, EPA's proposed a rule that would severely limit the authority of states to issue water quality certifications that protect their local water quality. It limits a state's ability to place conditions on a permit to protect their resources and narrowly interprets that 1 year time period in which states are required to act. It's kind of putting like a straitjacket on the process you'd want to see for kind of thoughtful review and the input at the state level. So now if a state exceeds this time period without making a decision, the state would waive the authority they have under Section 401. And that's an interpretation that completely ignores common instances where states need more information to make an informed and thoughtful decision. Do you have any concerns with EPA's proposed changes to the Section 401 authorities? And is it more likely, or is the potential that this restrictive interpretation of 1 year time period could result in states denying certifications in an attempt to avoid accidentally waiving their Section 401 authority? In other words, there's kind of a catch-22 potential here.
Yes, I'm not a big expert on the Clean Water Act, but I'm concerned that the new EPA proposal really is inconsistent with the whole spirit of the Clean Water Act. And I just think it's a further example of how divided and polarized everything is. The states feel powerless to stop these pipelines that are coming through, so they're using their 401 authority. And then EPA is maybe overreacting by really cutting back the whole 401, not just stopping pipelines. That'll really hurt states' legitimate water interests, which is an overreaction maybe to an overreaction. And yes, I do think states are going to say no because they don't want to be caught in the 1 year rule. So when it's the year's ending, they're going to say no, and maybe pipelines that are needed won't get built because states will say no because they have to say no. So I think a little more moderate, balanced approach would be better than the way we are now.
I appreciate that, and Maryland is experiencing this in one situation in particular, and that Section 401 authority. I mean, it's there for a reason, but it can only be meaningful for states in terms of protecting their water resources if there is some careful balance struck here, and I do have concerns that it's not happening. We want our federal agencies to work cooperatively with states and tribes, implement and enforce science-based water quality standards, and not impede their ability to fulfill those obligations under the Clean Water Act. So it's an important issue, one we'll continue to bring attention to, and I thank you for your testimony. I yield back.
The chair now recognizes the gentleman from Texas, Mr. Flores, for 5 minutes.
Thank you, Mr. Chairman. Mr. McMahon, thank you for being here. Thank all the panel for being here today. I'd like to talk about the impact of natural gas and its prices on electricity rates across the country. Data from the Energy Information Administration shows that residential consumers in my home state pay about 12 cents per kilowatt hour as of November 2019, while in the same time frame, residential consumers in New England states had almost double the rate at 21 cents per kilowatt hour. The abundant network for natural gas-fired electricity in Texas contributes significantly to our low electricity or our attractive electricity rates, while thinner availability of pipeline networks and natural gas in the Northeast is contributing to higher prices for consumers. Mr. McMahon, you mentioned in your testimony that amendments to Section 5 of the Natural Gas Act could impact a pipeline's ability to modernize and expand its infrastructure. Can you drill into that a little bit more for us?
Yeah, it goes back to what I've said earlier about being predictable and stable. Is making a retroactive refund on something where you've been following the rules. So a pipeline is charging its just and reasonable rate. It's been charging it, somebody complains, all of a sudden you have to go back and no longer, from the date that the rate is found to be unjust and reasonable, and refund dollars that you really had no control over because you were following the rules. It creates uncertainty. And anytime you create uncertainty in today's financial markets, it can affect your cost of capital. So if a lender or others are seeing that rates become more unstable, more uncertain, revenue streams become more uncertain, it's going to affect your cost of capital. As those costs go up, it may affect your investment decision on marginal or not as good projects.
Does reduced access to pipeline infrastructure adversely impact electricity rates?
Yes.
Okay. And so if pipeline infrastructure is being blocked for some reason in a particular geographic area, where do those states, where do those areas, those consumers get their energy?
On the electric side, Congressman, I'm not really good on how the electrons flow, but I think what you're seeing is the constraints that are in the Northeast is the pipeline capacity that exists has become very valuable and very constrained.
Right.
And so until those constraints are relieved, then the electric industry is going to have to move electrons around to meet those needs.
And so homes have to use heating oil to heat their homes. Electricity is obtained from legacy coal-fired plants, all of which contribute to higher prices for those consumers and which contribute to higher carbon emissions to the environment. So I appreciate the panel for being here. Thank you. I yield back the balance of my time.
The gentleman yields. The chair now recognizes the gentleman from Texas, Mr. Vesey, for 5 minutes.
Thank you very much, Mr. Chair. I wanted to ask Commissioner LaFleur a question. In your testimony, you discussed the evolution of the Natural Gas Act to reflect our nation's changing energy priorities. Specifically, you mentioned the notice of inquiry for FERC opened to take a comprehensive look at the pipeline process. You wrote that the development of a better process, ideally through a bipartisan consensus order, would be a more fair, clear, and efficient one than the one handed to FERC through court orders. Can you speak a little bit more about what that new process might look like? And I'd also like to, for Ms. Tierney to answer that as well.
Well, thank you for the question. As Dr. Tierney said, FERC has received literally thousands of comments in that docket. And I think if FERC would have to look at the several areas that are covered in the notice of inquiry, how it looks at need, how it does its environmental review, and how it does landowner rights, how it does the balancing test. I think in each one, FERC would have to come up with it. We couldn't just say, oh, we'll consider it all, put it in a big stew pot, and we'll come up with public interest. That wouldn't give anyone any certainty or predictability. And FERC would have to come up with new standards. For example, if you're looking at need, one thing I've said is if a state regulator said the pipeline is needed to serve customers, that carries a lot of weight with me, as opposed to just like we're bringing it to market and we'll see who wants it. So look at the different types of, look at the different cases that have come in and set new standards. But that's what FERC does. FERC has developed new policies on all kinds of things as the nation's energy system evolved. And similarly with environmental, you'd look at, okay, if we're going to look at greenhouse gases, what kind of information? One of the things FERC would really have to look at is, what do we ask pipelines to come in with? Now we just ask them, come in with your route, come in with your construction plans, et cetera, come in with your who has the precedent agreements. FERC would have to ask, what do you know about what the end uses are going to be? How long will they be there for? Then you could ask the state, how long do you think you'll be burning gas or whatever? They'd have to come up with new rules, not something that they would just do casually, but I think it's within the authority and within the competency of the agency.
Yeah, thank you. Ms. Tierney.
I would say just what she said. That I would very much agree with that. And I would just make one more suggestion. Right now, FERC adopts in many cases, provides a very thorough record, not complete, but thorough record on environmental impacts, but does not bring that into its review of whether a project is needed and whether it is needed in light of state policies that would call for a reduction in greenhouse gas emissions over time. So right now, the 1999 policy statement identifies that FERC will look at all relevant factors, but FERC is not doing that. So even going back to the actual letter of the original statement in 1999 would be better than today, because today the box is checked if you have a precedent agreement, and that is not consistent with a public interest test.
Yeah, good. Commissioner, what role do you think that FERC should play in the public understanding exactly how the pipeline process works and the everyday role that pipelines play in our lives? And what I mean by that is, obviously the groups that come up here are very well funded, whether they're from the fossil fuel industry or whether they're from consumer groups. They know what they're talking about. They understand exactly the role that pipelines play. But just the everyday person out there, whether it's this time of the year particularly, where you're going to get your natural gas from or how you're going to heat your home, the expansion of manufacturing in this company, climate change, all of those different things that these groups that are well organized know about, but I really don't think that the average person really understands that well. And what role do you think the agency should play in really helping educate the American public?
I think that, and this is something I've thought a bit about, FERC should put more effort into making it easier for members of the public to participate in its cases, potentially through more technology, through a more user-friendly website, or other ways that people who are like Representative Griffith's constituents who are directly impacted by something can come into FERC more easily. FERC has worked on that, but there's still a ways to go. As far as general education, I think FERC has a role. I think state commissions have a role. Often, the people who care the most are either the ones who are building the pipeline or the ones who it's going through their farm. But what about the people on the end that need the gas to heat their schools? Sometimes they're not in the docket anywhere. And I think those people need to be informed through FERC, through their state agencies, and through the industry of what the interests are.
Gentleman's time has expired. The chair now recognizes the gentlewoman from Washington, Ms. Boris Rogers, for 5 minutes.
Thank you, Mr. Chairman. Appreciate everyone being here today.
The shale revolution over the past decade has made the United States the global leader in natural gas production. It's striking to me, when I was first elected to Congress, there was a lot of concern about the rising cost of natural gas and our dependence upon other countries for natural gas supply. And today, we're one of the largest exporters of natural gas in the world. This renaissance of natural gas production has created hundreds of thousands of jobs, decreased prices of energy and home heating, increased American energy independence, and reduced emissions. We should all be proud of this responsible and innovative use of our natural resources. As countries like China and Russia seek to use their energy resources to pressure other countries, America must counter their influence with our natural gas exports. China is building hundreds of coal-fired plants in developing nations as part of their Belt and Road Initiative. Russia continues to use their natural gas, which is almost 50% higher in life cycle greenhouse gas emissions, to influence European countries. If we expand our LNG infrastructure, EIA estimates our exports can more than double by 2050. By replacing these coal plants in Asia, our LNG can reduce GHG emissions by up to 54%. Calls to ban fracking, block pipelines, and reduce our natural gas exports will result in the loss of hundreds of thousands of jobs, increased energy prices, increased emissions, and the spread of authoritarian influence globally. Instead, we should be focusing on continuing to modernize and build our infrastructure so that we can meet the world's growing demand for our clean natural gas. Mr. McMahon, the U.S. has arguably the most highly developed and technologically advanced pipeline network in the world. Combined with our tremendous shale resources, do you believe the U.S. has the global energy advantage when it comes to price and supply of natural gas?
I do.
And as a follow-up, how have pipeline and LNG exports helped our trading partners reduce their carbon emissions?
Well, as the pipeline industry has built out the infrastructure, the LNG facilities, a lot of them which were originally designed to be import terminals, are now exporting cargoes. So by providing LNG to the world, it is allowing us to put our natural gas at work in other parts of the country where they are, I should say the world, where they're burning coal, fuel oil, and other things. So I think it's been a very big boon to us to be able to export clean energy to the world.
Well, and as I mentioned earlier, I believe that we need to be expanding our LNG infrastructure to increase exports to markets such as Asia. FERC is the lead agency for siting interstate natural gas pipelines, and many state and federal agencies have a role to play. They may review aspects of an application, or they may be required to issue separate permits. To Mr. McMahon again, are you concerned that some states are using their permitting authority to block pipelines for political reasons?
What I will say is that over the last 5 or 6 years, we've seen it becoming increasingly more difficult to build pipelines in certain areas by inability to obtain the necessary permits.
So what suggestions do you have to improve the coordination for quicker decisions?
Well, I think that it's kind of twofold. Is the pipelines we typically build are those in interstate commerce, and those are crossing multiple state lines. The idea is that the Commission has found that the pipeline is in the public convenience and necessity, and it needs to be in interstate commerce. And it becomes very frustrating. It kind of goes back to my stability and predictability. Is if you're getting all the way out and you hit a roadblock because the state is holding up permits or refusing to issue or denying permits, then you may be getting to where the gas is actually very much needed, but it's blocked.
Right, and unfortunately, that's happening too much today.
It's happening more than it's ever in my career.
Wow. Well, our pipeline infrastructure has been so important, not just to Americans, but also to the rest of the world. So I appreciate everyone being here and appreciate the hearing today. I will yield back.
Lady yields back. The chair now recognizes. Chair recognizes himself now for 5 minutes for the purposes of an opening for questioning the witnesses. Ms. Turney. Hi. Beg pardon?
Good morning, Mr.
Good morning, good morning. As part of its public interest review, FERC relies on precedent agreements to determine pipeline need during the application review process. Do you think that this is sufficient to determine pipeline need, and what other factors should be included?
Thank you for that question. I certainly think that it's relevant to know in a FERC review of whether or not a pipeline is needed to see whether there is a precedent agreement. It is potentially very relevant as part of many different things that FERC should take into account. The other kinds of things are in the market for where there is demand for natural gas, is that market located in a state where the state has adopted a policy to eliminate fossil fuel over time in that market? FERC might be interested to know whether there would be stranded costs of a pipeline in that circumstance, and whether or not it would be a bad idea to allow yet another pipeline into a region. So demand is one thing, environmental and other state economic development policies, a variety of things. Those things could support need for a project or be against the need for a project in light of other pipelines that are already serving a region.
There is a small municipality, very small, in Illinois. It's a town called Pembroke, Illinois.
Okay.
In Pembroke, Illinois, there I'm not sure what the population is, but they have no access to natural gas at all. And Reverend Jesse Jackson Sr. is really making that a public issue, because the people are existing without any of the things that we take for granted. And are there, does FERC assess, are there citizens across the nation who may be dwelling in places, cities that are still in the dark ages as it relates to pipeline and access to modern conveniences such as pipelines?
I do think that FERC could take into consideration what's going on in a particular part. I'm assuming this is in the metropolitan area of Illinois.
No, it's not.
It is not, okay.
It's in the rural areas.
Okay.
So my point is that we you have a lot of discussions about deserts.
Yes.
Is there a pipeline desert in the U.S.?
This is true. And FERC
Well, is there one? Is there one? Is there a pipeline desert or natural gas desert in the U.S.?
I think there probably are parts of the U.S. where there is insufficient access to natural gas.
Yeah.
There are places, especially in, I think, pieces of New England, parts of the upper Midwest, that use propane delivered by truck because they don't have access to natural gas. Mostly little communities kind of on the edges of metropolitan areas.
And I would add tribal reservations are an example where they are deserts.
So, so my question to you is, are we satisfied with that? With that state for American citizens in the 21st century? Are we satisfied with that?
Well, I would assume that there are economic considerations that in which a pipeline company determined that it was too costly to build infrastructure to serve that low-density area. I'm not saying that's good or bad, but that's the system that we have.
And it's not good or bad, and I want to say it's insufficient. It's a travesty.
Thank you.
Right, because we have, this is the wealthiest nation in the history of the world. And the pipe, you know, we want to argue and make a point that we are energy sufficient, or that we export energy, and we have American citizens who don't have access.
Thank
to
you.
this energy.
Who's next? Olson? Johnson.
The chair now recognizes Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman. I'm really glad that we're taking up this issue because it's extremely important to the people that I represent in oil and gas country in eastern and southeastern Ohio. You know, we sit on top of the Utica and Marcellus natural gas deposits, and over the last few years, we've seen the incredible economic and geopolitical advantages that oil and gas activity is bringing to the United States. And today's hearing gives us a good opportunity to get into the weeds and hear from some of our experts on how we can responsibly get natural gas to the customer without compromising all the benefits that we're seeing from this abundance. So, Mr. McMahon, you know, we all know low and middle income households spend a larger share of their income on energy bills, so lower natural gas prices really help. In addition, in my district, we've seen growth in indirect employment surrounding new oil and gas development. Can you talk about the benefits that the average person sees, the person on the street, the person in the hills and valleys of eastern and southeastern Ohio, particularly those who may not benefit from direct employment in the energy industry?
Well, it kind of goes back to one of the big advantages is the availability now of natural gas. When I entered the industry, there was concerns about shortages and where the gas was going to actually come from. Now we have abundant natural gas. People have been able to enjoy low gas prices. It's also, as I've said earlier, had a manufacturing renaissance. And a lot of the products that, you know, are used in everyday use, such as some of the plastics and things like that, that, you know, everybody is buying are now becoming cheaper because they're being produced domestically, they're being produced with low-priced natural gas, which has driven down some of the normal products that people would use. So they're, even though they may not be employed or having direct benefit, the indirect benefits through lower utility bills, lower consumer prices on things that used to be manufactured abroad or used based on naphtha or something else are now being able to be used by low-priced natural gas.
Yeah, and you know, I've been saying for quite a while to people in my district that, you know, they've seen promises of economic booms around energy for a long, long time. I mean, Ohio has been in the oil and gas business for many, many years. In fact, the first oil well drilled on the North American continent sits just off of exit 25 from Interstate 77 in Caldwell, right in the heart of my district. And I've shared with folks that, take for example, you know, we got an ethane cracker plant that's going in across the river in Monaca, Pennsylvania. We've got another one in Belmont County that we're sitting on pins and needles waiting for the final investment decision, and it looks like everything is moving in the right direction. It's been my contention that these are just the tips of the iceberg, that in addition to low energy prices that natural gas brings, those that aren't employed in the energy sector will also benefit from the economic opportunities that are coming with these big petrochemical facilities, because when the textile manufacturers and the plastics manufacturers and others that use the ethylene and polyethylene and polypropylene that'll be coming out of those facilities for manufacturing, I think our region is going to be flooded with businesses that want to come and set up their operations there. Am I wrong?
No, I think what you've seen is you've seen the renaissance, especially along the Gulf Coast. You know, I mean, if you look at what's happened in Lake Charles and along the river corridor and New Orleans, Baton Rouge, you're now seeing in the Pennsylvania, Ohio, West Virginia area where things were historically just done along the Gulf Coast have now moved to the upper Midwest. And I think that, you know, the Gulf Coast has benefited for years. I think as you're seeing now, the upper Midwest is going to benefit equally.
Watch out, New Orleans, here we come. I yield back, thank you.
The gentleman is back, the chair. Write it down. The chair now recognizes Ms. Bergen for 5 minutes.
Thank you. I want to thank the panelists for being here today and talking about this issue. Climate change is an issue that's been very important to me. I want to do a little survey. Can you raise your hand on the panel if you agree with the scientific consensus that climate change is primarily driven by human activity? Okay, we got 3. Okay, now I'm going to ask the 3 of you to keep your hands up. If you believe that the FERC should use NEPA, or the National Environmental Policy Act, to analyze the climate impacts of pipeline projects as part of its determination of whether a project is or is not in the public interest, keep your hands up. Okay. So now we still have 3 of 4. In my view, I think it's basic common sense that at a minimum, if we want to reduce climate emissions, we need to evaluate further infrastructure projects for their climate impact. Otherwise, I think we're flying blind. Ms. LaFleur, can you please explain why evaluating climate impacts is common sense and how we can ensure FERC does climate impact analysis?
The National Environmental Policy Act requires FERC, because FERC's the lead agency for pipelines, to look at direct, indirect, cumulative environmental impacts. And it's clear to me, and the courts have said, that climate impacts, whether it's from methane emissions from the pipelines or downstream emissions, are an impact of the pipeline, so it has to be evaluated and disclosed as part of NEPA. I also believe that as part of public interest, that has to be weighed with some of the benefits of pipelines we've heard about, has to be weighed and balanced. How we can make FERC do it, I think either a court order or legislation is the only way to make FERC do it, or a different set of commissioners on FERC over time. I don't think FERC is inclined to do it right now, and that's the honest belief of the commissioners that are making those decisions.
Great, thank you. Dr. Tierney, the Trump administration's recent proposed rule to gut NEPA includes a provision that says the analysis of cumulative effects is not required. Would this proposed regulatory language direct agencies not to consider climate change when reviewing gas pipelines?
I would interpret that as a former administrative official. I would interpret that as a direction, but it would certainly provide an excuse for any agency that didn't want to move in that direction as well.
Taking it one step further, would removing the consideration of cumulative effects also mean that an agency reviewing the impact of a proposed gas pipeline through a community of color would not have to account for the existing environmental justice challenges in that community?
I would agree with what you said. Yes, I think that would be the case.
Great. Well, you know, I represent a district that's one of the most heavily polluted districts in this country, which includes the Port of LA, and there's only 4 districts in California that are poorer than my district. And oftentimes it feels like people come to our communities because they think the community won't stand up, or because they can't, or because they're working 2 jobs. And so, you know, climate is a real issue and a crisis, which is why our committee is working to going 100% by 2050. Thank you all for your work. With that, I yield back.
Gentlelady yields back. The chair now recognizes Mr. Long. Mr. Olson. Mr. Olson.
I thank the chair and welcome to our 4 witnesses. A special howdy to Michael McMahon from my hometown of Sugar Land, Texas. Y'all should know Texans love bigger. Bigger is better. And our hometown is the biggest town in the most populated congressional district in the country, Sugar Land, Texas, in Fort Bend County. We're also the most diverse county in America. So my friend
bigger is better. Feel free to brag about our state. And
Thank
now
you,
let's brag
Congressman.
about our energy. As you know, the shale revolution started in Texas with the Barnett Shale play, expanded the Permian Basin, Eagle Ford, all over the country. My question is, the point is, this has been a boon for America. It's made our air cleaner. It's created hundreds of thousands of good-paying jobs, not just here but overseas. It's allowed us to help countries. We talk about climate change, global warming. 2 countries contribute the most to that, China and India. And I'm proud to report that last year we signed 2 agreements with India for a total of $10 billion worth of natural gas exports to India. I've met Prime Minister Modi many times. He has said renewables are our future, but natural gas from America is our present. We're making their air cleaner, the world's air cleaner, by exporting our natural gas to these nations. Thank you for that. One other, it's kind of late, probably can't see that, but that's an LNG tanker ship coming from Sabine Pass going to Estonia. There's a crowd of people, maybe 100 people, waving flags as that ship pulls into the dock. You know, my friend, if we move the battleship Texas, we can't get 5 people to watch her move down the port of Houston. These people are there because they know this is their freedom from Russian high prices for energy. No more shutdown over conflicts with other countries. My point is, this is not just an economic boon for America, it's a diplomacy boon, a freedom boon for America. Now, the problem we're having here in America is getting the product we have to the market. You deal with it every single day. Pipelines, pipelines, pipelines. We all know the safest way to transport this product is via pipeline. We also know there's all sorts of impediments. For example, Kinder Morgan is trying to build a pipeline from the Permian Basin to the Houston area, get those ships there. They're being dragged down by Austin, Texas. Lawsuit after lawsuit after lawsuit. You're out there working in the real world. Please tell me how lawsuits and stuff coming down from D.C., it's sort of subtle. For example, the Keystone XL pipeline was a bellwether for people who want to attack pipelines. That pipeline was approved 3 times by the State Department, headed by Mrs. Clinton twice and Mr. Kerry once. Yet President Obama nixed it. That one single act got the whole pipeline market attacked by these groups to stop transporting these products, again, in the safest way possible. So can you elaborate on how these things in D.C. hurt your business and how we can streamline them and make it more viable without all the uncertainty of lawsuits and protests, et cetera, et cetera, et cetera?
Well, you're right, Keystone was a bellwether event in our industry, and the world has changed since then. You ask about, what happens when policies are changed or take a different direction is, as Commissioner LaFleur knows, because I was in talking to her about 2 or 3 weeks later, is when FERC announced this change in policy concerning the treatment of income tax for master limited partners. They announced it on a Thursday, I'm sorry. And by the following Friday, 9 of the largest pipeline companies that were publicly traded, including us, lost $15 billion in market value in that time frame. So action.
$15 billion just like that, snap of a finger.
So it goes back to what I've been saying all day long, is when you change stability and predictability and make us a risky business, the markets react very badly. And that's the concern we have anytime you make major shifts that affect our revenue streams.
One question about FERC, and maybe you want to answer this, Ms. LaFleur, as well. We worked hard to get them an office in Houston. That's coming online. How will that impact your business, all the people around the area with an office of FERC right there in Houston, Texas, Pipeline Central, Port Central, et cetera, et cetera?
I think the primary advantage of the Houston office is that with the growth of LNG facilities, it's been hard for FERC to hire enough of the kind of engineers that do the review of LNG facilities. And guess what? There's a lot more of them in Houston than there are in Washington, D.C. And so by having an office in Houston, FERC will be able to access that job market. I believe that's I discussed it when I was there. That's part of the plan.
And one final question. Mr. Doyle and I have a bill that allows FERC to charge higher salaries, like the FEC. They had some issues there with, not the FEC, the SEC in New York. All the expertise can hide away. The big guys have told me we hired the FERC guys because their expertise. Is this going to give you guys more authority to raise salaries for special employees?
I supported the proposal that came out, which I believe was just for certain kinds of engineers.
Yep.
I actually think, and I'm no longer anything to do with FERC, there's an inequity because as the energy work has become more complicated, other agencies like the Commodities Federal Trading Commission, the SEC, they get a higher pay grade for each level because their work is considered more complicated in some way. But I think FERC is right up there in complexity. So I would do it not just for the engineers, but the financial people too.
I'm out of time. Go Sugarland Skeeters!
And the chair, the gentleman yields back. The chair now recognizes Mr. Schrader for 5 minutes.
Thank you, Mr. Chairman. Appreciate it. I guess, Ms. McMahon, why was natural gas excluded from the 1988 FPA amendments?
Why, my remembrance of that history was you saw the natural gas industry was becoming to be moving from a bundled to a transportation. That started in 1985. It finished in 1992. I know of no causal link between what was happening in the gas industry, but I also know that what was happening in the electric industry is that was at a time when electrics were true monopoly providers, and they were had a bundled commodity and transportation. And the concern was people had no recourse when the price spiked, and that was the primary reason for the change in 206.
Ms. McMahon, would you agree with that, or do you have a different take or whatever?
I think she.
Or excuse me, Ms. LaFleur.
I think that part of the reason was that at that time, gas pipelines had to come in every 3 years to get their rates looked at. So they thought they didn't need this refund authority because they'd be looked at regularly anyway, something FERC did away with decades ago. And I think both gas and electric have changed a lot in the last 30 years, but in my mind, they're both imbued with a public necessity. The reason you can build a pipeline is because FERC says it's in the public necessity. That's why you can get eminent domain. And so part of that public necessity, I think, is making sure the rates are just and reasonable.
Ms. Tierney, would you comment a little bit on public necessity? You indicated, I think, your testimony is pretty much a done deal as long as you got a buyer or purchaser out there. What about the cost-benefit analysis? Should that also be, given all the pipelines and the controversy we've heard today about building different pipelines in relatively the same area?
Yes, I really think that in order for FERC to restore credibility in its decisions and to ensure that the public interest, rather than the private interests of two counterparties in a precedent agreement, that FERC really does need to look at benefits and costs as part of its need analysis. And there are many things that could go into that. There are many, we've heard today about many of the benefits of access to natural gas, but there certainly are costs, and many of those costs are shifted to people who aren't benefiting from natural gas. Landowners who value their land at a price higher than the market price and would like to keep their farm, for example. I could go on, but there are many different elements of a benefit cost analysis that I think would provide a better direct case for the public interest findings.
So, Mr. McMahon, would you comment on that, agree, disagree, and why?
Well, I think that I don't really disagree a lot with what Dr. Tierney said, but I think that the challenge you have is, when it comes to landowners, it is a true challenge, is to get a pipeline from point A to point B, you're going to cross landowners. And each landowner you cross may or may not view it as being any value. That is the challenge of the industry, and we understand, and I think if you look at the number of reroutes you see on a pipeline between the time it's proposed and the time it's actually constructed, it demonstrates that we are taking those concerns. But eventually you have to go from point A to point B, And as I said earlier today, as I said, we're working on getting better with landowners. We still have a ways to go. But, you know, there's going to be somebody that's going to have a valid objection to your presence, and that's something I haven't quite figured out.
So why, I guess, we desperately need another pipeline out in the Pacific Northwest where I'm from. We got one, and we'd like to have some redundancy there. Why not build it in the right-of-way? There's existing rights-of-way, highways. Why not? It's going to be more circuitous, I get that, but at the end of the day, you have more, I would assume, more certainty you're going to get it done without all the legal lawsuits and all that.
We try to use existing pipeline corridors. We try to use existing power corridors. Sometimes you'll see us co-locate with water pipelines, but we try to co-locate wherever possible. You know, the engineers would love to take the most, you know, straight route, but that's just not doable. But so we try, and, you know, I think a lot of our projects, and Commissioner LaFleur, I think this is a fair number, is between 50 and 80%, almost every pipeline being about co-located.
That sounds essentially right. A lot of it is co-located. It's the places that it's not where it's really more difficult.
Yeah. Seems like a way to avoid some controversy when possible. Thank you very much. Now you're back, Mr. Chair.
The gentleman yields back. The chair now recognizes the gentleman from North Carolina, Mr. Butterfield, for 5 minutes.
Thank you very much, Chairman Rush, and thank you again to the witnesses. There's been a lot of discussion about the need to reform Section 5 of the Natural Gas Act. To achieve this, last week, along with Congressman Billy Long, we introduced H.R. 5718, the Protecting Natural Gas Consumers from Overcharges Act. The bill is very simple, in our opinion. It amends Section 5 by taking the exact same language from 206, Section 206, to give FERC identical refund authority for natural gas and electricity. So I'll begin with Ms. LaFleur. The bill that Congressman Long and I introduced gives natural gas customers, would give natural gas customers the same rate protections that electric customers currently have under the FPA. Judging by your opening statement, you would agree, it seems, that amending Section 5 with mirrored language from Section 206 would put natural gas customers on a more level playing field for the rates that they pay as compared to the rate protections electric customers currently enjoy. Am I on track with this?
Yes,
Yeah.
and I also think it would place them on a more level playing field with the pipelines, because there's an asymmetry now between the leverage that the pipelines have. That's why pipelines can, at times, threaten to file a Section 4 if somebody brings a Section 5 against them, because there's an asymmetry of power, and I think it should be level.
You also mentioned in your opening statement that the refund authority in Section 206 enable FERC to require almost every electric company to promptly pass along cost savings from the reduction in the corporate tax rate contained in the Tax Cut and Jobs Act to the electric customers. Did natural gas customers have the same experience?
No, it took much longer, because FERC can't order a natural gas customer to file, a natural gas pipeline to file a rate case. That is not authority FERC has. So FERC had to go in a very roundabout way to make gas customers file the financial information that FERC could use, and then ultimately 30% reduce their rates over, but usually more than a year, 18 months later.
According to the Congressional Research Service, which is a part of this institution that all of us rely on very heavily, only one Section 5 rate case has been filed by a third party since 2009. Mr. Worsinger and Ms. LaFleur, can you explain why a third party may be hesitant to file a Section 5 rate case? Mr. Worsinger.
Congressman, I believe that's because of how cost prohibitive it is to take that case forward. In our case, in the city of Wilson, we would spend more on that Section 5 filing with attorneys than what it costs us for the transportation of our annual natural gas supply.
So it's an economic consideration that you have to do. Would you agree or disagree, Ms. LaFleur?
I think the cost is a big issue. I've heard anecdotally some small customers are afraid to file because of the leverage that the pipelines have over them. And I also think since 2009, FERC has every year gone through and looked at pipeline rates. So rather than spending the money to file, the customers come into FERC and lobby for FERC to file, which it sometimes does.
Thank you. My last question is back to Mr. Worsinger. Mr. Worsinger, natural gas prices are low right now and will continue to be for the foreseeable future. Fingers crossed. Will amending Section 5 to give FERC refund authority actually make a difference for the people that you and I care about?
Yes, Congressman, I believe it will. The Natural Gas Supply Association puts out an annual study based on pipeline data that's been submitted to FERC. The last study they issued looked at the years 2013 to 2017. They examined the FERC data for 32 pipelines, found 21 of those pipelines were over collecting. 5-year period, that was $4.6 billion. That's billion with a B. That to me, sir, is real money.
Thank you. All right, I'll give you back 30 seconds, Mr. Chairman.
Chair appreciates that.
Thank you.
The chair now recognizes my friend from the great state of New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair, and welcome to all of our witnesses. Certainly, it's an important hearing, and it's great to have your input. Public interest determinations are supposed to look at the costs and the benefits of each project. And so, Chair LaFleur, can you help us understand the outcome of the Sable Trail case? More specifically, what does it mean that FERC must consider the downstream greenhouse gas emissions of projects?
The issue in the Sable Trail case was whether FERC had properly done its environmental review and its public interest review, and in particular, whether FERC was required to look not just at the direct impacts, like of the construction of the pipeline, but at the indirect impacts of the gas. Because why do you move gas? There's only two reasons. One is to burn it, either in a power plant or in an end use, and the second is to use it in an industrial process to make something. There's only no other reason to move gas. So the court said, resolving something that had been in dispute for a long time, that if a pipeline was built to move gas, FERC had to consider the environmental impacts of at the end of the pipeline as well as the direct ones.
Thank you very much. And during your time at FERC, and since then, do you believe that the Commission has adequately addressed these given considerations?
There's been disputes about how Sable Trail should be interpreted. Some commissioners read it very narrowly to cover a case where there was a specific single-purpose pipeline just to one power plant, but not other pipelines that were also transporting gas to be burned. I was of a view that it covered other situations, but there was we'll say a legitimate disagreement as to what it covered, but I started dissenting or doing my own separate statement where I did the greenhouse gas computation myself, which that should scare everyone if a lawyer is doing that, because I didn't think FERC was doing it right.
Well, thank you. And I believe some commissioners have suggested that FERC isn't able to conduct this analysis. And yet, as you share with us, it was very interesting in your testimony that you said you did your own GHG impact analysis. So, bold attempt.
If I could do it, then, yeah.
Can you give us a sense of what you did and why you believe it was important?
Well, I felt at a minimum, after Sable Trail, at a very minimum, we had to disclose and consider the GHGs. What I did was try to get as much information from the record, which the wonderful FERC staff would extract, and my own staff, of how much gas was going to go through, and I would make simplifying assumptions, like if there was no evidence of what the gas would be used for as a tie-in measure, I do a full burn. Imagine the pipeline was full every day. How much gas would it transmit? And if you burned it, what would it put out? And then calculated it by EPA standard GHG per ton. But if you did it more carefully in a new process, you could get real information on how much is the pipeline going to be used, what will it be used for, what will it replace. If it's replacing coal, you deduct those coal emissions from the ones that you calculated, or deduct the gas from the coal, so you could do it much more precisely than I did.
So do you believe that FERC can do what you did, and does the capability exist to do an even more robust?
FERC could definitely do the math and do it more robustly than I did. The hard part is, so then you get that number, what do you balance it with? And that's where FERC would have to do more work than it does now to get the benefits and the need for the pipeline.
Thank you. And would this require using the social cost of carbon, or are there other metrics that could be utilized to inform a public interest determination?
I believe FERC could use the social cost of carbon because that's the most available metric for measuring what the impact of the greenhouse gases is. But I think if FERC did a docket, other people might propose other ideas. I don't think that's the end of the story, but there'd have to be some way to do something predictable and quantifiable.
Thank you. And Madam Chair, you supported some projects after doing your analysis. So I'm assuming you don't believe there should be no new projects under any circumstances, but rather recognize that the law requires climate impacts to be given proper consideration. Is that an accurate assessment?
Yes, that's exactly what I believe. I'm not against pipelines, and I also think even that LNG export can be a part of a global climate strategy, but it has to be considered carefully, not just either all approved, as Dr. Tierney said, or none approved. There's got to be a way, this is FERC's job to figure out which ones are good.
Well, I agree, and I believe FERC should do a much more robust public interest determination on several factors, but at the very least, consideration of climate impacts certainly are clearly required by the law right now. I thank you for that, and with that, Mr. Chair.
Gentleman yields back. Now the chair recognizes the lady from the state where the center of the attention of our democracy is focused on. The great state of New Hampshire. Ms. Custer is recognized for 5 minutes.
Thank you very much, Chairman Rush and Ranking Member Upton, for holding this important hearing. As we heard from our witnesses and my colleagues in Congress, have a clear obligation to bring the National Gas Act into the 21st century and ensure that the Federal Energy Regulatory Commission acts in a fair manner. But fairness is truly the key word, because right now the vetting process at FERC for natural gas pipeline permitting is not fair to those who oppose or even have concerns about pipeline projects. Many of my constituents discovered this harsh reality several years ago when a pipeline project cut an indiscriminate path through my district. Property owners who stood to lose their land felt that their voices had not been heard. That pipeline would have cut through 39 parcels of conservation land in 15 different towns in southern New Hampshire. These communities worked hard and invested significant resources to make sure that these lands were preserved because they recognize the tremendous importance of the land's region's environment. And suddenly it was in danger of being taken away. That experience is part of the reason why I introduced the Protecting Our Conserved Lands Act last year. My bill would prohibit gas pipeline companies from using eminent domain to take land that is being permanently conserved by local governments or nonprofits. For these entities, often the only hope they have of their land being saved in the face of a pipeline are the environmental reviews under the National Environmental Policy Act. And they might not even have that anymore, given that the Trump administration's new proposed rules will gut that process. My bill doesn't rule out pipeline construction, but rather compels pipeline companies to work with local stakeholders to find reasonable alternative solutions. So a question for Susan Tierney. Dr. Tierney, you noted in your testimony that in the last 2 decades, FERC has approved 487 natural gas pipeline projects and rejected only 2. Given this dramatic disparity, could you speak to the importance of taking public input seriously during the approval process, particularly given the implications for those who will be impacted by eminent domain?
Thank you for that question, Congresswoman. One of the reasons why I think it is so essential that FERC do a better job of looking at the public interest test and go beyond the existence of a precedent agreement as an indicator that a pipeline approval would be in the public interest, is that the conveyance of a certificate approving a pipeline enables a pipeline to go and use eminent domain, attempt to use eminent domain. If you can't determine that a project is truly in the public interest, then effectively, you're going to enable the taking of land for private interests. That's really challenging for conservation land in particular that's already set aside for the public interest. So that's really a tension. But even the taking of private property for a private purpose, I thought that was unconstitutional. So I would encourage a indication from Congress that FERC really needs to do a better job of upholding the public interest standard.
Well, another characteristic of New Hampshire, in addition to the first in the nation presidential primary, is a proud heritage of respecting private landowner rights. The proliferation of gas pipeline expansion has thrust the following question into the foreground. What is more important, building more fossil fuel pipelines or respecting the individual property rights of landowners? Do you have an opinion?
I do, and I lived next to your estate for 35 years, so I appreciate New Hampshire's beauty and its feistiness, I'll put it that way. I think that it is essential to be looking at these various public interest issues as part of the whole calculation of whether or not a pipeline is needed. In New England in particular, every state has a goal of reducing greenhouse gas emissions. So the additions of new pipes should be looked upon with some concern about whether or not that's going to lead to stranded cost, whether that is an overbuild situation for the long term. And if my land were being taken for something that ended up not being needed, I'd be pretty mad.
Thank you. I appreciate that. I think FERC does not have a fair process now, but we can take a holistic approach, and I'm excited to work with my colleagues to get this done. I yield back. Thank you, Mr. Chair.
The gentlelady yields back. The chair now recognizes Mr. Bouchard for 5 minutes.
Thank you, Mr. Chairman. Mr. McMahon, can you specifically discuss how does the electrical market differ from the natural gas market? And is there a chance that there's a chance it would increase overall costs for both pipeline companies and consumers to create a similar or a parity situation between the two industries?
Yeah, the electric market is, if you go back in time, is not nearly as competitive as the natural gas market. Our pipelines are competing with each other and our customers to move capacity. The basic structure and the way, we've been unbundled for a number of years. Electric have just gotten there relatively in time. But I think that the biggest thing that is concerning for us, and the reason it would lead to increased cost, is the retroactive nature of the relief when we have been following our just and reasonable rates. And I've heard twice today about the tax increases and it not passing through. And I just want to remind the committee that FERC has had a long-standing practice where it comes to gas pipelines that interstate pipelines are not allowed to engage in single rate making issues. So if the tax rate goes up, we can't say our rate should automatically go up without taking a look at all of our costs. The same thing should work on the downside.
Okay, can you walk me through the process you take to resolve right-of-way easement issues without the use of eminent domain?
Yes. When we start a project, and this has been an iterative process over the years, and I'm speaking broadly for the entirety of the membership, most of the right-of-way acquisition starts about the time the application is filed with FERC. We start meeting with landowners, going through preliminary routes. At that time, if we've actually filed our application at FERC, we've had probably 1 to 3 town halls, depending on the length of the project. We've shown the route, we've met with local officials. So we start about the time the application is actually filed, negotiating with landowners. The INGA group, as I say in my testimony, has had about a 90% success rate of reaching agreements with landowners without ever instituting any aspect of an eminent domain proceeding. unfortunately, we've still got some work to do to get from 90% down to closer to 100%. But we start early and we talk often.
Yeah, I mean, I think that's important, public engagement and for what the necessity of the project is. When you create new pipelines, does that exclude the use of that land for other purposes?
No, in most cases, and especially in kind of your area where there's a lot of farms, is we will put a pipeline in, then the farmers are allowed to go ahead and farm over the top of the pipeline.
How deep do you put your pipelines on average?
On average,
is it variable?
Yeah, it varies, but unless a landowner's made a specific request, in most cases it's between 36 and 48 inches deep on a minimum side.
Okay.
Sometimes it's deeper.
Because, I mean, I think we've created this perception that everywhere a pipeline goes, the land's just not used, and there's just a pipeline there, and the land can't ever be used again, but that's not necessarily true.
No, it's not. In some areas, in the south, you see a lot of deer stands and stuff that are using the pipeline right away. We've worked with a lot of wildlife, National Wild Turkey Foundation and others, to use the right of way for wildlife revegetation or wildlife uses. So we work with the landowners. We understand that we're going to be partners with them for a long time. And like I said, in most cases, we're successful in reaching agreement with the landowners.
I mean, the climate's clearly changing, and we need to do what we can with technology and innovation to lessen our impact on that. I don't think there's anyone that really at this point disagrees with that premise. I just think the wrong approach would be to say, well, we're going to limit infrastructure based solely on that issue. And I think there are some people talking about in the public interest, they don't see fossil fuels ever in the public interest. And so that's kind of what we're up against as far as creating a balanced approach here. And so I would be hopeful that we can, whatever solution we come to with this legislation, that we can create a balanced approach that takes all of those things into consideration. Thank you. I yield.
The gentleman yields back. That concludes our first panel, and I would like to thank our witnesses for joining us today on this important issue. At this time, I would ask that the staff prepare the witness table so that we may begin our second panel shortly. And I really want the panel to know you're very much appreciated, and your testimony has been a source of enlightenment to the entire subcommittee. Thank you very much, and enjoy the rest of your day. Have some lunch. from the second panel of esteemed witnesses, and I'll introduce those witnesses. From my left, Ms. Maya Van Rossum, the leader of the Delaware River Keeper Network. Mr. Gene Barr, who's the president and CEO of the Pennsylvania Chamber of Business and Industry. Mr. N. Jonathan Perez, the Senior Director of the Energy Markets and Utility Regulations for the Environmental Defense Fund. Dr. David Malino, Legislative and Political Director of the Laborers International Union of North America. Mr. David Bookbinder, who's the Chief Counsel of the Niskanen Center, and Ms. Jennifer Dennis, who is the staff attorney for the Environmental Law Clinic, Columbia University School of Law. I want to thank you all for joining us today, and we look forward to your testimony. And at this time, the chair will recognize Mr. Perez for 5 minutes.
Thank you, Mr. Chairman, for the opportunity to appear before you to discuss implementation of the Natural Gas Act. We recognize that natural gas is a major part of the energy system and will be for some time to come. To reap the full benefits of the nation's gas abundance, we need to minimize emissions from the system and use gas efficiently. We believe that well-designed energy markets should stimulate competition and reward innovation, thereby advancing the public interest and beneficial environmental outcomes. EDF is not opposed to new pipeline capacity, provided it is economically justified and based on legitimate market need. To achieve that, it is essential to have effective regulatory review. FERC staff have observed that pipeline capacity investments over the past 10 years have largely relieved natural gas pipeline constraints, with a few notable exceptions. This suggests that it is not economically rational to add additional pipeline capacity at the rate at which we have in the recent past. And if such growth continues, it may come at the expense of the financial health of the pipeline industry and investors, as well as the interests of energy ratepayers. In recent comments to FERC in its pipeline ROE docket, James Murchie, the CEO of one of the largest equity investment firms focused on energy infrastructure, stated, quote, "Building unnecessary pipelines is risky to investors and a waste of capital," end quote. Put another way, adding pipeline capacity when it is not economically justified diminishes the value of existing capacity and investor expectations. What we are seeing is a disturbing trend of new pipeline capacity being proposed and built outside of rational market signals by utilities acting on both sides of the deal, both as pipeline developer and pipeline customer. Such utilities are forming affiliates to develop pipelines and then signing contracts with those developers, obligating their captive retail customers to pay for unneeded pipeline capacity to benefit their shareholders. This is occurring even when and where there is excess pipeline capacity serving the same market. To date, a majority of the Commission has been unwilling to explore whether there is actual market need in such instances as required by the Natural Gas Act. That brings me to the Spire project in Illinois and Missouri. FERC approved the project based on a single contract between the pipeline developer and its affiliated gas utility without rigorous investigation of need and without reasoned consideration of information presented by other parties. Spire's pre-application solicitation for pipeline customers yielded no bona fide market interest. The Missouri Public Service Commission opposed the project, stating that, quote, Spire's application for a new pipeline does not contain sufficient detail reflecting new demand for gas capacity, end quote. Demand in the area is flat or is shrinking. Numerous parties to the FERC proceeding cautioned that rate increases could arise for customers served by existing pipelines if contracts were shifted to the Spire project from those existing pipelines, which is exactly what occurred. These are precisely the types of adverse impacts to customers and existing pipelines serving the same market that the Commission is compelled to review and mitigate, but they are refusing to do so. EDF believes that FERC unlawfully approved the Spire pipeline without a sound determination that the project is in fact needed. We have petitioned the U.S. Court of Appeals for the D.C. Circuit for review of FERC's order approving the Spire project. That is the only FERC pipeline approval we have appealed. Let me emphasize that unnecessary infrastructure imposes real damage to landowners, ratepayers, and the environment. I have visited the families and farms impacted by the Spire project. When the Commission falls short in undertaking its duties in examining the need for additional pipeline infrastructure, there are very real consequences to people who deserve better. EDF's interest is to ensure that the market efficiently channels investment to where it is needed, which does not result when FERC fails to meaningfully review the need for new pipelines and, in effect, condones anti-competitive behavior. By refusing to examine project need, the Commission may well be imposing economic harm on the very pipeline industry that they seek to safeguard. Thank you for the opportunity to appear before you today. I look forward to your questions.
The chair now recognizes, in the correct order now, Ms. Mayor Van Rossum for 5 minutes. Ms. Van Rossum, you're recognized for 5 minutes.
Thank you, Chairman Rush, Ranking Member Upton, and members of the committee for giving me the opportunity to testify here today. In my role serving as the Delaware Riverkeeper, leader of the Delaware Riverkeeper Network, and founding member of a national coalition of organizations battling FERC-regulated pipelines known as VOICES, I have experienced firsthand the many ways that the Federal Energy Regulatory Commission has abused its authority and the law in order to advance fracked gas infrastructure. The Natural Gas Act clearly needs to be reformed in order to prevent further FERC abuses. Amongst the most essential fixes is an update to FERC's mission. FERC's misplaced focus on advancing, quote, plentiful supplies of natural gas at reasonable prices, end quote, rather than the public interest, encourages FERC to misinterpret and misuse the law to advance decisions that trample on due process, property, and states' rights. FERC's mission must be updated to focus on advancing energy sources that are genuinely in the public interest, including that of future generations, with a priority on advancing clean and renewable energy, and making clear that environmental rights, people's rights, states' rights, and the property rights of the public versus private industry are given priority in FERC decision-making. Amongst FERC's most egregious abuses are the following. Using a strategy called tolling orders, FERC routinely puts project challengers into a legal limbo that prevents them from challenging FERC certifications in court, while at the same time FERC allows the pipeline to advance full steam ahead, exercising eminent domain and construction, including clear-cutting forest land, blasting through bedrock, and trenching through waterways. FERC's January 31st pronouncement that it is going to prioritize landowner rehearing requests and try to meet a 30-day review period does not displace the need for Congress to act. First, FERC has no credibility on the issue. Second, this is just a policy that can be taken away as quickly as it is now seemingly being given. Second, non-landowner challenges will only be considered, quote, only when time permits, end quote. Some of the most important precedent-setting cases were brought by organizations like mine for the benefit of landowners and the community as a whole. But when we bring our challenges, we will now still be subject to tolling. And realistically, this means that forests, wetlands, streams, wildlife, and impacted landowners and non-landowning neighbors can all continue to suffer grievous harm while we are forced by FERC into tolling order limbo. FERC continues to refuse to consider the climate-changing impacts of pipelines and LNG facilities, including the downstream uses, the upstream production, and during the transmission of the gas. Fracked gas is a dirty fossil fuel. It is a dirty fossil fuel that is having devastating impacts on the health, the lives, the safety, and the environments where it is taking place. And it absolutely does impact the way landowners can utilize their lands. It impacts the success of businesses and agriculture, and it impacts the sense of safety and sanctity of people living in their own homes. By ignoring the harms of climate change and approving unneeded pipelines, FERC is exacerbating and even locking in our growing climate crisis. And as such, climate change is an essential part of the public interest consideration. FERC falsely claims that it has no way to consider the climate change impacts of the pipelines that it's approving, but this is a ludicrous argument that has been repeatedly debunked. The social cost of carbon is a proven and available tool. FERC routinely undermines states' rights by issuing conditional certifications, followed by quick approval for eminent domain and construction before a pipeline has received State 401 certification or approvals by other agencies. This undermines the ability of states and these other agencies to engage in full, fair, and unfettered review and decision-making, because, frankly, it's harder to deny or modify a pipeline that's already half-built. Similarly, and as a result, in a growing number of cases, property rights have been taken and irreparable construction damage inflicted for a project that did not secure all needed approvals and may never be built. And just in one final note, I'd just like to note that the precedent-setting contracts that you heard about earlier that are used as a demonstration of need, all too often, increasingly, routinely, these are contracts made by the pipeline companies with their own subsidiaries and affiliates. So it's a very clear-cut case of self-dealing in trying to approve need, or trying to prove need. Thank you.
The chair now recognizes Mr. Barr for 5 minutes.
Chair, Ranking Member, other members of the committee, thank you very much for allowing me the opportunity to participate here today. I'm the President and CEO of the Pennsylvania Chamber of Business and Industry. My name is Gene Barr. The Chamber is the largest broad-based business advocacy group in the Commonwealth of Pennsylvania. We have about 10,000 members and represent roughly 50% of the private sector workforce. Our members include people who develop energy, move energy, sell energy, and obviously use a whole lot of energy as well. The reality is energy is necessary for economic development. Many of the members here today have asked questions that certainly move directly towards that point, and we would certainly concur to that. What I'd like to do today is talk a little bit about what impact natural gas development has had in the Commonwealth of Pennsylvania. And it's both ironic as well as welcomed that Pennsylvania, which was the home of the petroleum industry in the United States beginning in 1859, has now basically come full circle. We are now number 2 in natural gas production in the United States, and with all due respect to some of the honorable members of the committee here from Texas, we'd really like to be number 1. We're going to be working on that one. So we're going to keep trying. We also have the number 1 natural gas producing county in the United States, Susquehanna, up in the northeast part of the Commonwealth, right up against the state of New York. A year or two ago, Pennsylvania, like many other states, went after the Amazon projects pretty hard. Everybody wanted those jobs, well-paying jobs. And we didn't get it. I mean, look, as in my capacity, I was certainly disappointed we did not get Amazon. The reality is we've had 2 Amazons in Pennsylvania. We've had 100,000 jobs created because of the development of natural gas in the Commonwealth of Pennsylvania. This has helped us, when you look back to when this began more than 10 years ago. The jobs that were created, and you'll hear a little bit later from our colleagues in the labor industry, those jobs that were created helped the Commonwealth weather the recession that we had. And we got through that because, in many cases, of the natural gas industry. It's feeding billions of dollars in investment now. Shell announced, and you heard it referenced earlier, a $6 to $7 billion investment in western Pennsylvania for an ethane cracker. We certainly welcome that as well. The impact tax on the industry that we created a few years ago has given $1.7 billion back to every single county in the Commonwealth of Pennsylvania for all kinds of projects, including broadband, recreation, infrastructure, et cetera. There's been billions of royalties paid to landowners across the Commonwealth. And one of the things that isn't talked about a bit, and I know open space is always a concern, I've talked to farmers who have said, hey, I was ready to sell the farm. People believe Pennsylvania is Philadelphia and Pittsburgh, and that's about it. The reality is Pennsylvania is heavily agricultural, in many cases rural. A lot of the farms that were in trouble, as unfortunately many agriculture operations are in this country, they've had the ability, because of royalties, to save that as open space and to be able to basically take the royalties and keep that for their families and to keep that open space there. That's significant. Talked a little bit today as well about the cost savings. Consumers have saved and continue to save roughly about $1,500 per year per household. That's significant. We also heard today a little bit about the air quality improvements. CO2 certainly, but also what are called criteria pollutants have all declined as a result of increased use of natural gas. It's also helped other states too, because Pennsylvania is an energy exporter. So those electrons that cross the border certainly help other states control as well. Interestingly, we've heard today a little bit about the polarization and the partisanship. In Pennsylvania, the industry is supported by both Republicans and Democrats. One of the strongest supporters, of course, has been our current Speaker of the House in Pennsylvania, who's a Republican, but our governor, who's a Democrat, strongly supports building out the infrastructure. The Democrats in the western part of the state particularly have already seen the benefits in terms of the Shell facility as well as the other development that's out there. The county exec, I just spoke with him yesterday in Allegheny, a strong supporter of that. He and I discussed this project. To be quite blunt, the current problem we have is an inability to grow the industry much as we would like, frankly. There's a problem. We've got lower prices. The prices have been depressed. That has resulted in, unfortunately, a lessening to a large degree of investment. We've seen some adverse decisions recently. Part of that is related to our own success. Some of the wells are more prolific than the companies even thought they were, but in reality, trying to move that product out of the Commonwealth into other areas has become certainly a problem. Mr. Chairman, you referenced pipeline deserts. We'd like to address those. We think that you hit on one of the real problems that we do have. And another thing that was noted was the fact that we're bringing Russian natural gas into Boston Harbor. To be quite blunt, that shouldn't happen. Not with what we have in our Commonwealth that's relatively close to New England. And bringing it from a country that does not have our environmental standards. We're more than happy to send our natural gas up there. We're more than happy to send natural gas to other places in the world. We believe it's certainly exceptionally clean. We believe that it's very much a positive and can contribute in many ways economically as well as environmentally. I greatly appreciate the opportunity to appear before the subcommittee and look forward to your questions. Thank you.
Thank you. The chair now recognizes Mr. Molino for 5 minutes.
Thank you, Mr. Chairman. On behalf of the Laborers International Union of North America, the men and women who dedicate their lives to building this country, I would express our gratitude to you and to the ranking member for inviting us to testify here today. LIUNA is an international union with more than 500,000 workers in 400 local unions around the United States. We are proud to be a leader in the fight to highlight our nation's infrastructure needs and to represent the men and women in the trenches who can do something about it. LIUNA members build the nation's core infrastructure, transportation, water systems, energy networks. We construct sewer systems, dig tunnels, assemble renewable energy projects, and build pipelines. We strive to work with our employers and industry partners to create bipartisan policies that improve opportunities for business, workers, and consumers. We strive to enact sound policies that restore sanity to the way the United States produces and distributes energy resources while protecting consumers and the environment. During the Great Recession, unemployment in the construction sector reached nearly 30%. The good jobs created by the boom in North American energy development was literally a lifeline for tens of thousands of our members. These are good unionized jobs that require a high degree of training and expertise. They pay family-sustaining wages with good health insurance benefits and will help provide a pension for the workers when they retire. LIUNA has been at the forefront of the labor movement in trying to forge an energy policy that reduces greenhouse gas emissions. We encourage all members of Congress to put aside partisanship and collaborate to truly address the infrastructure and climate crises. For a construction laborer, the next election is an eternity away, but their next paycheck and their next house payment is just around the corner. Bitter political fighting in Washington is not even a distraction when you're trying to make it home safely with a fair day of pay for a hard day of work. They don't care about jobs and industries that don't exist yet when there is a job in front of them right now, one that leaves something behind and actually benefits their community and their country. I want to stress that LIUNA believes in an all-of-the-above approach to energy development. In addition to pipeline infrastructure, LIUNA members have built solar plants in the California desert, wind farms in the Midwest, and we are working on a nuclear facility in Georgia right now. Creating a political climate where energy resources are allowed to be developed after they are vetted, reviewed, and permitted will not allow an enormous amount of private investments to create millions of new jobs across all sectors of the economy. Our nation's natural gas production can fully meet our domestic need for natural gas and help supply our allies and trading partners abroad, as we've heard several times today. However, to take advantage of this abundance, we need to expand our energy infrastructure systems to safely, responsibly, and efficiently transport natural gas to consumers. This includes additional natural gas gathering, transmission, and distribution infrastructure to deliver this energy to power plants, manufacturers, and local natural gas utilities and consumers. Congress should be taking steps to ensure that public policy advances these goals instead of stifling them. It is time to develop a rational energy policy that protects both the environment, consumers, creates good jobs today, and develops new industries that will be a source of jobs in the future. The Natural Gas Act establishes a framework that facilitates the timely and efficient modernization of energy infrastructure needed to connect energy producers and the consumers. LIUNA supports a common-sense energy policy, one that replaces foreign sources of energy with domestically produced resources that fosters domestic job creation instead of funding foreign extremists. Our members support incrementally lowering emissions, which seems to make more sense than the all-or-nothing approach embraced by the political extremes. There is dignity in work, and nobody should be attacked or degraded because they seek to earn a living or provide for their families. In the construction sector, job creation comes from investments, sometimes public investments into roads, bridges, tunnels, and water systems, sometimes from the private sector seeking to serve consumers' needs. The infrastructure build-out itself creates opportunities for America's skilled trade workers. At LIUNA alone, our members have seen work hours on transmission pipelines increase from around 10.5 million hours in 2015 to 22 million hours in 2018. And LIUNA is just one of 4 unions who are signatory to the National Pipeline Agreement that covers the unionized work in this sector. Our brothers and sisters in the International Union of Operating Engineers, United Association of Plumbers and Pipefitters, and the International Brothers Teamsters have also seen the same amount of work hour increases. This isn't a Republican or a Democratic issue. There isn't a single American worker who doesn't want affordable energy, good roads, safe bridges, and clean drinking water. Our policymakers should work together to achieve these goals. Thank you for the opportunity. I look forward to answering any questions, and we appreciate being invited to talk here today. Thank you.
The chair thanks the witness. The chair now recognizes Ms. Dennis for, no, I'm sorry, Mr. Bookbinder for 5 minutes. Sorry.
Thank you. Chairman Rush, Ranking Member Upton, thank you for inviting me to testify. I am David Bookbinder, the Chief Counsel in the Scannon Center here in Washington, D.C. And first, I'd like to say the Scannon Center is not opposed to natural gas, and the Scannon Center is not opposed to natural gas pipelines. Previously, before joining the Scannon Center, I represented natural gas industry interests here in Washington. But building pipelines is not just a one-sided deal. On the other side of building pipelines are property rights. And that's a cold term. I want to stop using the term property rights. I want to talk about people and their homes and their land and their farms to which they have a deep attachment. That's what we're dealing with, not something called property rights. We're dealing with people and their land. There are a lot of problems with FERC's process. I want to briefly touch upon two procedural and one substantive. The procedural problems begin with notice, and Representative Griffith was talking before about the surprise he felt when he learned that a pipeline was coming to his district. Landowners have that same surprise when they don't get notice, which happens, but the first real problem is they get notice in a half-inch stack of paper, and buried in there is the fact, usually in one sentence, single-spaced half-inch stack of paper, that they have a limited amount of time to intervene in FERC's administrative process. And that's important because unless you intervene, you can't ask FERC to rehear its decision, and you can't go to court to challenge FERC's decision. Intervention is critically important, yet it is something that landowners don't learn about until after the intervention deadline is passed. FERC has no regulation establishing a uniform period of intervention. They simply pick a date. It's as little as 13 days after people get that notice. People do not have enough time to understand what all this stack of paper means. They don't understand what intervention means, and they certainly don't understand what it means that they have to get this done in 13 days in an extremely confusing manner. For instance, just one example of this, in the documents FERC provides, or rather that the pipeline company provides, there are 3 separate sets of contradictory instructions as to how to intervene. And it's detailed in greater detail in my written testimony. The other problem with that initial notice is it's not provided by FERC. FERC delegates the entire process of providing the constitutionally required Fifth Amendment due process notice. The entire thing is delegated to the pipeline company. And pipeline companies are the ones who have the least interest in providing adequate notice. And as a matter of fact, we've been becoming interested in how they do this, and we asked FERC, we did a FOIA request to FERC, what policies or procedures do you have in place to ensure that pipeline companies are actually providing this notice to all the landowners? And the response was, a search of our non-public records have indicated we have no documents responsive to your request. That's astonishing. FERC delegates this task, this critically important constitutional task, to the pipeline companies, and then has zero oversight procedures in place to see that this notice is given properly. The second procedural problem I want to touch upon comes at the very other end of the process. Notice on one end, the condemnation procedure on the other. And what has happened is that pipeline companies have developed something with the acquiescence of courts called quick take. And essentially what it means is they get access to the land, they get to build the pipeline, but they don't have to pay compensation until years later. And that is fundamentally unfair and runs counter to a whole lot of things that we believe in, including the whole just compensation issue. But the idea that a company can take the land, cut the trees, build the pipeline, and pay you for that years later is fundamentally unfair. And this needs to be addressed along with the notice issue. Lastly, I would want to say that I actually want to thank Chairman Chatterjee and FERC for taking seriously one landowner concern, which Ms. Van Rossum touched upon, which are tolling orders. And the chairman seems to have taken this to heart. The most recent pipeline decision from the commission came out within the required 30 days. And we're appreciative that FERC has taken this seriously and is trying to do something about it. Thank you.
The chair thanks the witness. The chair now recognizes Ms. Dennis for 5 minutes.
Thank you, Chairman Rush and Ranking Member Upton, for the opportunity to testify. My clients, New Jersey Conservation Foundation and the Watershed Institute, are nonprofit environmental groups that have fought for decades to preserve New Jersey land and water. The proliferation of unnecessary fossil fuel infrastructure has emerged as a significant threat to their core mission and to the health and welfare of New Jersey residents. While I will discuss the PennEast project specifically, I want to call out 2 major problems with how the Commission evaluates pipelines. First, the Commission condones condemnation without requiring evidence of public need. And second, it does so without knowing whether the project could ever be built consistent with the Clean Water Act. Since PennEast's inception, lands held by these organizations or their members have been in PennEast's crosshairs, their ownership threatened by eminent domain, their ecological integrity imperiled by a project purporting to satisfy the Gas Act's public need requirement with LDC affiliate contracts. Worse, independent energy experts demonstrated that PennEast's intended service region has a glut of gas capacity. On the coldest day of the bomb cyclone, winter 2018, New Jersey shipped gas out. There was simply too much and no shortage of infrastructure. New Jersey is not a gas desert. The state ratepayer advocate opposed PennEast, likening the certificate to winning lottery ticket, unsupported by public need and actually causing public harm. Just last week, the project shape-shifted. Calling it an amendment, PennEast proposed an entirely new project claiming independent utility, relying on different undisclosed contracts, and sending gas to different places. This highlights the errant way the Commission administers the Gas Act. No court has heard the merits of PennEast's original flawed route. It may never be built without essential missing federal environmental authorizations. PennEast's new submission effectively acknowledges that it doesn't need to build in New Jersey, but New Jersey lands have been condemned nonetheless. The Commission shouldn't discharge its duties in a manner permitting private companies to take land, while also insisting that courts have no role in ensuring the Fifth Amendment's limitations are respected. Congress can fix the Commission's current administration of the Gas Act, realigning it with its core purpose of protecting the public against excessive corporate power and halting these unacceptable practices. All PennEast needed to condemn land was a Commission certificate, but it got this by self-dealing, showing that its LDC affiliates, the ones that created PennEast specifically for this venture, would buy what it was selling, self-generated demand for capacity. These LDC affiliates pass costs along to ratepayers, while PennEast receives a 14% rate of return just for building. Public need and public interest are entirely absent from this equation. Not only did the Commission rely on affiliate contracts rather than market data, it skipped another part of a critically important constitutionally sufficient public use analysis, determining whether a pipeline, even if supported by genuine public need, could be built consistent with the public's interest in preserving water quality. The Commission also punted on PennEast's climate change impacts, claiming it has no way to put that on the scale. The Commission did prepare an EIS for PennEast, but openly sidestepped federal environmental authorizations. PennEast's certificate relied on an EIS lacking data for over 60% of the New Jersey route. Somewhere along the way, the Commission decided that certificates lacking required federal environmental authorizations satisfied Gas Act Section 717 FE's public interest standard. Courts found that such certificates didn't violate the Clean Water Act because everyone understood that they don't authorize construction. Therefore, they can't hurt water quality. But no court has examined whether this kind of a half certificate is a constitutionally sufficient basis for allowing PennEast, who is not legally authorized to build its project, to seize land. Importantly, to prevent significant water quality damage, there's every indication that PennEast could not be built along the route it condemned. While the Commission can attach post-construction environmental conditions, certificates lacking federal environmental authorization should be insufficient to trigger condemnation. Landowner harm was compounded because nobody could challenge PennEast's certificate before condemnation proceeded. When we went to court to defend against condemnation, the judge, and this happens across the country, considered questions regarding Fifth Amendment or the fact that a half certificate was not the kind Congress anticipated when enacting Section 717 FH to be impermissible collateral attacks. Despite legal impediments to construction, condemnation on environmentally significant lands has proceeded. The Commission's administration of the Gas Act fails to serve the public, contravening the Act's main goal, protecting the public interest. The proposed Clean Future Act reform will restore this goal, allowing condemnation to proceed only for projects that the public actually needs, which can be built without destroying water and air quality. Thank you for your time.
The chair thanks all the witnesses, and we have concluded the opening statement from the witnesses, and now the chair recognizes himself for 5 minutes for the purposes of questioning the witnesses. Ms. Nannis, I was very intrigued by your testimony, and can you focus more attention for me on the impact of eminent domain use before legal obligations are met? I think you kind of thoroughly, or at least you hit upon a lot of those abuses. Are there any additional abuses that you have in mind?
Thank you for your question, Chairman. I believe that two of the primary considerations that have just fallen out of commission practice are ensuring that before the commission condones condemnation by the pipeline applicant, that a project actually could be built. People's farms should not be taken before a state that has the authorization under Section 401, as we heard this morning, to determine that a project is too harmful to water quality and that it can't be built. The commission ought not to authorize condemnations before that finding. And there's really two reasons for it. One is land will be taken for a project that may never be legally authorized to be built. And the second is that the commission's public interest determination ought to include environmental considerations. If a state finds that a project will violate water quality and harm its residents and the access to clean and safe water, then the commission, without that information, can hardly be said to be making a proper public interest determination. It can't determine what it doesn't know, and if it doesn't know that, then it can't make a public use finding that's constitutionally sufficient.
Ms. Van Rossen, do you think that FERC should allow pre-construction and construction to proceed prior to issuing a rehearing order? And if you would, in your answer, describe the impact that this has on surrounding communities?
Thank you for that question. Absolutely. I think that the Federal Energy Regulatory Commission should not be approving eminent domain authority or construction prior to all permits and approvals being granted, and certainly not prior to the ability of challengers who are concerned about what's happening with a project getting their day in court. There are actually multiple pipelines where challengers, whether they were landowners or concerned community members that were going to be impacted by the devastation to the forest lands and the waterways, the environment, and impacts to the communities, filed their rehearing requests and then became the subject of tolling orders that were in place anywhere from 7 months to 2 years. And in fact, in a number of instances, in at least, I think it's 21 cases, before that tolling order was lifted, before the challengers had a chance to even file their paperwork in court, the pipelines were already fully constructed and starting to operate. So they never even got to file their paperwork. The numbers are really devastating. Every time somebody files a rehearing request in order to be able to bring a challenge against a pipeline project, every time they get met with a tolling order. And again, those tolling orders are in place anywhere from 7 months to 2 years. There is no good reason for a tolling order because when they are finally lifted, it is always a denial of the rehearing request. Rehearing requests are never granted, right? So that means that we know when somebody files for a rehearing request and a tolling order is issued, we know that the tolling order is going to be denied. What that really means is that the only good reason to issue a tolling order is to give the pipeline company time to advance their project through eminent domain and through construction unfettered by a challenge by anybody. That is a tremendous misuse and abuse of authority by the Federal Energy Regulatory Commission. The tolling order practice should be ended, and in fact, if the law should be amended to say, if there is a tolling order in place, no eminent domain, no construction until tolling order is lifted. We maintain the status quo for everybody. That would be fair and equitable.
The chair, time is up. The chair now recognizes the ranking member.
Yeah, I know that I had to step away for a little while, so I'm going to defer and go to Mr. I'll go at the end of the queue, so I'll go to Mr.
Okay.
Flores first.
Thank you, Mr. Upton, for doing that, and thank the panel for joining us today. This has been informative. Mr. Molino, I have a couple of questions for you. First of all, the backdrop for the first question is this.
Sorry, I should have.
I introduced legislation in the last Congress called the Pipeline Interagency Coordination for Review of Natural Gas Pipelines Act. It passed the House on a bipartisan basis in the last Congress. And basically what it does is it makes FERC the lead agency to coordinate all interagency and activities, including activities by states and local governments in the permitting process, so that we have a more reliable and consistent pipeline permitting process. And so, in your view, how do delays and red tape affect the work of your members?
Well, we know that a standard strategy is to delay these projects until the companies walk away. And I don't want to get into parsing numbers about approval rates and everything else, but I can guarantee you there are members of ours who have gone to work on projects that have been proposed, and commitments have been signed for our members where the companies have walked away from those projects because the approval process and the repeated objections and stalling delays and court tactics and everything else have killed those projects.
Based on the experience
So
of
it's
you
been
and
a real problem.
You and your members and your workers, how would you recommend that the permitting process be modified?
I'm not a permitting process expert in terms of what the process is. I don't practice that kind of law. I don't practice any kind of law. Even though I've gotten a law degree, I know better than to make those mistakes on behalf of clients. But we would like to see the process streamlined, have some concurrent timelines, so that you don't have to go through this agency and then that agency and then that agency and then that agency, and then go to the governor and then go back to the courts, and then so some sort of certainty in the process, so you know what the timelines are. You give the people a chance to have their cases heard. But once a project is permitted, it should go forward.
Okay, great, thanks. That's essentially what our bill does, and if you do want to take a look at it and give us some feedback, that'd be great.
We will.
Also continuing with you, Mr. Molino, let me give you some backdrop for the second question. As you're aware, we've had protesters that have protested at pipeline construction sites, either construction sites or finished pipelines, and not only have they taken firearms and attempted to damage pipelines by shooting at them, but they've also attempted to turn valves and so forth. I don't think, they call it free speech. I don't call it free speech. I call it terrorism. Fortunately, there have been no fatalities or serious injuries from these activities. But do you believe that these protests are becoming more common?
I think with the Keystone XL pipeline was talked about during the first panel. Those of us who were involved in the Keystone XL pipeline from the very beginning, and the laborers were, we had a project labor agreement on that. We still have one when that project is built. Changed the dynamic of the political discourse around these issues. And we've actually had workers had to be pulled off of projects because of violence and threats of violence in the past, while local authorities could get things in order. And again, as I said in my testimony, nobody should be attacked or denigrated for trying to provide for their families.
Mm-hmm. And so your workers actually felt like they were endangered because of these?
We've had companies suspend construction and have the workers not report to work until things could calm down.
When the last Pipeline Safety Act went through this committee, I added provisions to greatly increase the fines, the criminal penalties for those types of activities. Do you think that was an appropriate measure?
I think that's a question for you guys to deal with. We obviously think vandalism is very serious, and and penalties should be enforced, and those crimes should be prosecuted.
Do you think there's any other activities that Congress should take in this regard to keep our workers, our communities safe?
Oh, I got a whole laundry list for you.
Oh, well, I'd like to hear those.
Meet with you someday. But no, we need to strike a balance here between, the need of the consumers, the economic needs. We don't dismiss property owners' property rights. Our members use this land. We care about environmental stewardship to just lump us in that we're on one side or the other. You know, our union has a lot of issues on a lot of different issues, and we take a balanced approach to all of them, and we think that everybody should be a little bit more common sense about that.
Thank you for your feedback, and Mr. Upton, thank you for yielding me your time. I yield back the balance of my time.
The gentleman yields back. The chair now recognizes Ms. Berrigan for 5 minutes.
Thank you. Ms. Danis, in your written testimony, you write that an accurate balancing test that prioritizes the public interest is critical. It's very important from the testimony we've heard today that FERC's application of the Natural Gas Act is out of balance. What reforms can be made to the Natural Gas Act to ensure that pipeline reviews value our constituents and landowners rather than solely corporations?
I think that, as Dr. Tierney testified this morning, one of the single biggest problems is skewed market signals and manufactured demand, essentially. So a reform would be to enact amendments into the statute, which the Commission, and as we heard this morning, is in the 1999 Certificate Policy Statement. The Commission will not just rely on one showing of need and will not just rely on a precedent agreement, which is a private contract between private parties. But in particular, the situation now is exacerbated because it's not an arm's length contract. Right now, it is a contract between a private company and its affiliate, and then the situation gets worse. Its affiliate can pass any costs incurred along to ratepayers. So in effect, everyone in my community, in your community, is paying for the pipeline company building to earn 14% rate of return, and the LDC affiliate to turn back capacity on legacy pipelines and pass the cost along to ratepayers. They get hit twice or 3 times in the process.
Great, thank you. Ms. Van Rossum, last fall, my office received a letter from your organization signed by over 100 local environmental groups calling for hearings into FERC's shortcomings in reducing fossil fuel projects and how that is impacting communities across the nation. This really resonates with me because communities in my district are frontline communities, oftentimes black and brown, that are bearing the brunt of the nation's reliance on fossil fuels. Can you please speak to the environmental justice issues from proposed pipelines that your organization and the communities it fights for has encountered?
Sorry. Absolutely. It's a very big concern that those with lesser power, those that are minorities, those that are from black and brown communities, from indigenous communities, frequently get targeted for highly polluting industrial operations, including pipelines, fracked gas infrastructure, and LNG export facilities. Also, low-income communities get targeted. There needs to absolutely be a reform to the process to take into consideration the very important environmental justice issues. And I would say that many from the coalition that you heard from, called the Voices Coalition, that my organization, Delaware Riverkeeper Network, helps lead, they really would like the opportunity to come during an expanded hearing to be able to speak with the members of Congress more directly about the experiences they're having and the solutions that they've identified.
Great. Your written testimony also speaks to the need for Congress to reform FERC's mission to prioritize advancing clean energy and retiring rather than expanding fossil fuel infrastructure. I'm excited by this idea. Can you elaborate on it?
Yeah, so as I testified earlier, FERC is very forceful in its assertion that really its primary goal is about advancing fracked gas infrastructure, about advancing pipelines and LNG facilities. And in their day-to-day practice, they very frequently, while they will allow people to speak about environmental and climate change issues on the record, they actually ignore those ramifications and ignore those harms in reality in their decision-making process, giving priority to the misinformation that the pipeline companies present to them for decision-making. So we believe believe that the mission of the natural gas that's identified in the Natural Gas Act for the Federal Energy Regulatory Commission needs to be very, very clear with the commissioners that they do need to prioritize environmental justice. They do need to prioritize the protection of future generations. They do need to ensure that consideration of climate changing impacts and environmental impacts are given high priority. And they do need to prioritize and say that if there is another way to serve the energy needs that are being claimed by the pipeline company, for example, clean and renewable energy options, that too needs to be given priority into the decision-making process, and that FERC should be entitled to, and in fact should be required to reject fracked gas pipeline projects when there is a clean and renewable energy option instead.
Great. Thank you so much. I yield back.
The gentlelady yields back, and now the chair recognizes my esteemed friend from the great state of West Virginia, Mr. McKinley, for 5 minutes.
Thank you, and I share that friendship with you. Thank you, and you've always been fair, and these are good hearings we have. I represent northern West Virginia, north central West Virginia, right in the heart of the Marcellus and Utica and the operation. And when I go back to the district and I have my town hall meetings or roundtable discussions, the school boards, the county commissioners, individuals can't comprehend that Washington would even consider stymieing this reformation in our economy in West Virginia, that they would stop the pipelines, they would stop the fracking. So I thank you, Ms. Van Rossum and Bookbinder and Danis. You helped make my case. Your statements are spot on to show that it's true. You are a threat to this economic redevelopment of West Virginia, and maybe the country, for that matter, with your attitude. Because, Van Rossum, let me go back to you were so adamantly opposed to fracking. Fracking's been around 1860, then 1840s, the hydraulic fracking taking place. We had Lisa Jackson come in here in 2011, I remember, because I asked the question, and said, there is no evidence at the EPA that any fracking operation has upset someone's water quality. None. 2011. Now, Ms. Danis, you talked about there's excess gas. Come to West Virginia then. We've had gas-fired power plant had to shut down during the polar vortex of 2014 because they couldn't get gas. They couldn't get pipelines constructed because of people like Bookbinder and others that are supporting the idea of banning, stopping crossing properties to get this pipeline. So I thank you for your 3 testimonies. You've helped make my case that I can take that back to when I go back to my roundtables again to show it is a true disaster headed towards us. So let me turn to Melina, if I could, with you. Since you and I came up through the building trades, I before you.
You a little bit.
Yeah.
But I went to school in your congressional district, so we're even.
That's right. I'd like to understand for the impact on the economy and our workers, our operating engineers, our laborers, all the people that are involved in it. What has been the economic impact of the stopping the Atlantic coast? Because we want to ship that gas down to North Carolina. They could use it and burn it cleaner than they are with coal. But he's stopped from doing that. So the Atlantic Coast Pipeline, the Mountain Valley Pipeline, show me what's been the impact of that.
I mean, just to take West Virginia, for example, a laborer on one of those pipelines in West Virginia, or any pipeline in West Virginia, will make about a $30 an hour on the check wage. There's almost another 20 in fringe benefits, pensions, health care, and associated fringe benefits. So every time those workers aren't working, that money, they either have to try to find something else, if there is something else out there. And we watched, during the Great Recession, that these jobs were the jobs that brought Western Pennsylvania, Central Pennsylvania, West Virginia, Ohio, brought these workers back into the economy. And without them, they would have been unemployed, and they would have either had to leave the industry, leave the state, go find something else. they were absolutely essential jobs, and they are essential jobs for these workers.
David, do you have anything to show the delays on the Atlantic Coast Pipeline? How much money has been sitting on the table as a result of that?
I don't have that handy, Congressman. I'd have to go back and take a look, and we could probably pull some data. But you know, again, it's hard on those workers because they want to work.
How about the last question in the time that I have remaining? Often they'll say to our industry, because I started in the construction industry in '65, these are all temporary jobs.
Right.
How do you react to when people talk about our careers,
you know,
nothing but temporary jobs?
Particularly within the unionized sector, which you're familiar with. You know, these temporary jobs help you earn a pension. I don't know many temporary jobs that provide you a pension. They provide you a good middle class living. I don't know many temporary jobs that provide you, for the course of your career, 20 or 30 years, a career. Temporary jobs aren't careers. Construction's a career. One of my colleagues here in the room often states that he has a member who's retired from his temporary jobs. You know, 25 years of temporary jobs. And you know, these are private investments. This is not the federal government having to figure out how to pay for highways or bridges. This is private investment. These are private jobs that aren't reliant on federal spending, and they're very important to our members.
Thank you. My time's expired. I yield back.
The gentleman yields back. The chair now recognizes Mr. Peters for 5 minutes.
Thank you, Mr. Chairman. Thanks for the witnesses. I had to be away a little bit, but I did have some questions. To start with Ms. Danis, is that? I read your information, and you know, put aside for a second whether the use of the Natural Gas Authority under this act is the right way to regulate the industry as a whole. What I talked about at the first panel was an idea about whether you could condition the approval of a pipeline on something like methane capture. In other words, to meet the benefit to the public test. Did you have any thoughts on that?
Yes, and I think this goes to a point that was raised by the last question. The Natural Gas Act provides that the Commission makes a case-by-case determination about each project. If all pipelines were in the public interest, we wouldn't have certificates. And Section 717FE specifically provides that unless a project is in the public interest, in fact required by the public interest, it shall be denied. And it gives the Commission broad authority to attach conditions to the certificate to ensure that it's in the public interest. That conditioning authority has been extensively used by the Commission, and I see no reason under the law and with the vast reservoir of authority that the Commission has, that the Commission couldn't attach conditions on a certificate to employ best available technology to reduce methane, or to ultimately weigh a project, the economics versus the environmental harm, to determine that that particular project doesn't measure up and doesn't serve the public.
Okay. To me, that would be one constructive way to talk about it, although I would expect we would want to have a set of standards that we would agree upon in terms of pipeline technology, and I think that wouldn't be that hard to come to, I suppose. Mr. Paris, I wanted to say, to also ask you in more general terms is, how do you see the definition of natural gas as a bridge fuel? So we talk a lot about natural gas as a bridge fuel, but no one seems to have designed the bridge. Some people think it's a lot longer than other people think. What's EDF's perspective on that?
So in the first instance, I think market participants and those that invest capital have the biggest dog in that hunt, so to speak, in how viable their investments are on the long run. Pipelines are extremely expensive. But to get more specific to your question, one thing that the Commission has not been doing is doing a realistic assessment of the useful economic financial life of these assets when they permit them and when they're built. The system is designed for them to take evidence on that fact. So when you're, for example, building a pipeline that serves an end user in a state that has a robust climate law that requires reductions, it is probably not rational to assume that that pipeline is going to have a 50 or 60-year useful life. So ultimately, this question about a bridge fuel is a question about looking at the policies that apply to the use of natural gas in the jurisdictions in which it will be delivered, and ultimately allowing investors to weigh those, presuming that FERC does what it's supposed to do from a regulatory standpoint and weighs those sorts of policies, makes a legitimate determination about the public interest, considering both state public welfare requirements.
So I guess in this context then, with the Natural Gas Act, your determination of the viability of natural gas would be determined by demand according to the state regulations to which the gas would be shipped?
In some circumstances, the commission needs to consider, in the context of the public interest, the public policy requirements in the states into which that gas is being shipped. So as I said, New England is a very easy example.
Yeah.
I mean, you've got a set of states that have very robust climate laws. Right. And what has been the outcome of that? It has not been that people are stopping pipelines from being built into New England. It's that investors don't want to risk money to build pipelines that they know will not last through a meaningful, useful life in dealing with those public policy laws.
How does the fact that they're using home heating oil in New England factor into the pipeline analysis?
Pipelines are very expensive to build. What's happened in New England is pure and simple. The cost of building pipelines has not been worth the returns that investors would pursue. Okay. And so, yes, if there was short-term access to lower emitting fuels, that would be a good thing, but that's not what's going to determine whether pipelines get built into New England.
Thank you.
The gentleman yields back. The chair now recognizes Mr. Griffin for 5 minutes.
Thank you very much, Mr. Chairman. First, I would ask unanimous consent to introduce a letter from Carolyn Givens about her experience with a pipeline in our area. Not your area, my area.
Seeing no objections, so ordered.
I appreciate that very much. I'm not going to bore the committee with a recitation of all the things I said previously. I appreciate Dr. Bookbinder mentioning some of the frustration that my constituents have felt in his statement. We definitely have to have more meetings, and we need to find a way that we can respect property owners, the people, the land. As I said earlier, one of the folks, and these folks I've actually mentioned today by name are here and have been here for the whole hearing. These are folks who are invested in the land, family land. I know it's got to be true in other parts of the country too, but in my neck of the woods, people have been on the land, or their families have been on the land for 100 plus years in many cases. So the question that comes up is, how can we incentivize companies to figure out a way to reach a resolution with landowners? Because while there may be people who just want to stop, and I recognize that, I don't remember who said it now, Mr. Barr or Mr. Molina, who may want to just stop pipelines at all costs. A lot of the folks that in my area are just concerned that they've put it on the wrong part of the farm, if they'd move it this way or move it that way, or take steps to not, when they're putting it in, to recognize, for example, we have karst formation, it may just appear to be a shallow cave to you, but it's something that the family's been using, going in and out of, exploring for years. Let's not blow it up. Move it someplace where you don't have to break something up. Anybody got any ideas on how we can incentivize the process so that companies, instead of just coming in and saying, here's where we're going and drawing a line on a map and then fighting tooth and nail to make that line work, try to figure out ways to accommodate historical, cultural, and topography differences that actually might make it better in the long run and make the community feel more a part of the process. Anybody got any ideas? Yeah, Mr. Barr, go ahead.
I'll be happy to chime in. I believe it was Mr. Molino who mentioned about some folks who want to block at all costs. And to be honest, there is a lot of that.
Sure, there's some of that, yeah.
Who legitimately don't want fossil fuels, period, and see this as an opportunity. I think companies, the ones that I've seen when we've had pipeline projects in Pennsylvania, there's one particularly went down through the Lancaster, Pennsylvania area. They did meet actively with the residents there, and they reach certain compromises to go around certain areas, certain stands of old trees, et cetera. I think they certainly believe it's in their best advantage to do that. I believe it expedites the process. It helps to move these things along. It helps to do that, and I think I've seen companies do that and do that with great effect and help to move their projects along. As we heard earlier as well, unfortunately, there were still people who wanted to stand on the pipeline, block the pipelines, et cetera, and that certainly continues to be an issue, and we do see an issue with a lot of the vandalism issues in the Commonwealth of Pennsylvania as well.
Well, and I know that you want to get into, but I would just tell you that has not been our experience, and I think there was just some miscommunication between people within the company building one of our pipelines in particular, or maybe both of them. But I've had too many constituents tell me, and in one of my counties, when that Board of Supervisors member called me, it really did look like they just drawn a line on the map. They turned all the conservative farmers that had been there for 100 years against them in the span of a couple of days, just because they weren't talking to people. So not everybody does that. We got to figure out a way how to solve that. Mr. Perez.
Thank you. The pipeline industry, the pipeline developers are not a monolithic industry. And
I understand that.
some pipeline developers do a far better job than others do.
And sometimes companies do a better job on one project than they do on another. I understand.
And specifically, when I spoke about the Spire project, I've been out and visited those farmers and those families and those legacies. And the challenge that they've had is Spire is not an experienced pipeline developer. They're chasing a buck. And so typically you see a company like that does a worse job in terms of dealing with landowners and landowner rights than some of the other companies that have been doing this for years. There needs to be minimum standards. They cannot be seizing land in advance of being fully permitted and reviewed.
And minimum standards makes sense. Dr. Bookbinder, I got about 8 seconds, sorry.
Yes, one of the things I would suggest would be there is a federal statute that governs how property that the federal government is going to take under eminent domain. There's a procedure that is used in terms of...
And you recommend that for pipelines?
Yes, which should be made applicable to pipelines.
I appreciate it. Thank you.
Gentleman yields back. The chair now recognizes the gentleman from Massachusetts, Mr. Kennedy, for 5 minutes.
Thank you, Mr. Chairman. Thank you for holding this hearing, and again to the second panel, thank you for being here today. As I mentioned in my earlier comments, our current energy policies are unfortunately sidelining communities and landowners in favor of industry interests. Back home in Massachusetts, we are watching those flaws come to life as a compressor station in Weymouth is being built despite the rejection of the local community, including an ongoing hunger strike now of over a week by at least one active and engaged citizen in my district. And recent changed circumstances that reflect significantly decreased market demands. I've called on Chairman Chatterjee to issue an immediate stop work order due to these concerns, and if he's watching, I'm urgently and not all that patiently waiting for his reply. FERC is allowing the project to move forward without reviewing updated information on market need, since precedent agreements have fallen through since the time that the project was approved. Mr. Dennis, I'm not going to ask you to comment directly on this specific project, but I think your experience in Pennies is instructive. Up in Massachusetts, many advocates, experts, and citizens have gone to extreme measures to ensure that their voices are heard. As I mentioned, hunger strike, nonviolent protests, and sit-ins included. You spoke to this briefly in your testimony, but could you outline specific barriers to public engagement and how they've impacted the Pennies project specifically for landowners?
Thank you, Congressman. For the Pennies project, trying to get at that question of what the economics are was really a tricky feat. We submitted a FOIA request to the commission, and we asked for their economic analysis supporting demand for the project and that the project would serve the public need. The response letter that I got back said, it's the precedent agreements and you already have them. That's a significant issue. The second significant issue that you referred to is that for the Pennies project, while the economics were done in 2015 and it was unsupported then, it's 2020 now. The world has changed. Additional capacity has been brought online. I'm sure that this is happening in other communities. And communities are suffering from authorizations that were made at a time and in a manner when the economic situation and the proliferation, really the explosion of gas capacity hadn't happened yet.
And so building off of that, I think PennEast has proposed to split its proposed pipeline project into two separate segments. And so has PennEast demonstrated a need for those two separate segments through disclosing updated precedent agreements?
No, in fact, in its new filing that happened just last week, PennEast has not even named the shippers that hold the precedent agreements for the new Phase 1. And their precedent agreements that are signed, they state but don't disclose for only about 50% of the capacity. And given the fact that the primary capacity was held by New Jersey LDCs, it's difficult to understand how there could be public need for New Jersey LDC shippers if those are, in fact, the shippers that are holding the contracts.
And so you explained earlier that FERC must legally consider environmental impacts of projects as part of their public interest determination. Can you talk briefly, unfortunately, about what the consequences of the failure to meet those legal obligations are in your community and what it is nationwide?
So I kind of break it up into two categories. One is the failure to have any Clean Water Act analysis. And in the Natural Gas Act, it's very clear the Natural Gas Act is not supreme over other federal environmental laws. Clean Water Act, in fact, has a provision allowing states to preclude projects that would significantly damage water quality. At the time that the Commission prepared its environmental impact statement for the PennEast project, it had no information for over 60% of the route in New Jersey. It is really hard to understand how the Commission could do a public interest analysis that weighs environmental costs of the project with absolutely no data on what resources it would be harming.
And can I ask you for a yes or no on this one? In your opinion, should the public interest determination also include factors like potential employment and job loss? Should the potential employment loss or job loss, should that be part of a public interest determination?
Loss from failure to construct, you mean?
Yes.
I think that the public interest determination should consider all economic factors, and that's certainly one of them.
Thank you. And Mr. Molino, in your testimony, you discussed the importance of American labor being at the forefront of reducing greenhouse gas emissions and endorsing a comprehensive strategy to combat climate change. As our economy transitions towards renewable energy in the coming years, how can we best make sure that we best work with you to prepare American workers in about 15 seconds?
I mean, our workers stand ready to help build out any infrastructure that you want that is incentivized. You know, we've been doing infrastructure our entire existence as a union. Our union endorsed, somebody made reference, I think it was disparaging, to the long markup of Waxman-Markey. LIUNA endorsed Waxman-Markey. We've endorsed a comprehensive approach to climate change and dealing with greenhouse gas emissions. But what we can't do is stand by and watch these projects get opposed individually by individually, because this is designed to trap the resources and strand the resources. And this Congress, any Congress, should take a look at these issues in a comprehensive manner and stop bowing down to the stop this project, sign a letter opposing here. We want a comprehensive approach to climate change, and we want comprehensive investments to make these transitions good for workers, but we're not going to do it when we're fighting these fights over one project after one project, because there will never be one project that has 100% unanimity. I would love to have some projects that are identified by environmental groups that they can live with, that we could work and move forward on. But there is a dearth of them, whether it's renewable projects or natural gas projects or whatever it is. We are fighting this fight every single battle, every single project. Not even energy projects, every single construction project has some NIMBY who doesn't want it to go forward. And we can't plan for, our workers can't plan for their retirements and their future, sorry, Mr. Chairman, in that kind of climate.
Thank you, sir.
The gentleman yields back. The chair now recognizes the gentleman from Ohio, Mr. Long, for 5 minutes.
I'll take that. I'm Bill
sorry,
Johnson from Ohio. Thank you, Mr. Chairman. It's been a long day.
It's been a long day. You don't know how long.
Mr. Molino, it's good to see you here with us today. I wish my colleague, Mr. McKinley, were still here.
I'd point out that if you had driven just a little bit further west, you'd, rather than stopping to go to school in West Virginia, you could have come to, you know, the home of three of the top candidates
was
for
right
the
up the
Heisman
road.
Trophy, The Ohio State University, right? But it is good to see you. So I wanted to ask you, I know that LIUNA members don't just work on pipelines. Can you talk more specifically about the types of energy construction jobs that your members perform?
Sure, it runs the gamut, in all honesty, from you know, building transmission projects like pipelines, on coal-fired power plants. Our members do turnaround work when those power plants have to come offline, and be tuned up. Our members in Ohio and West Virginia often rely on those hours, on those turnaround hours in coal-fired power plants. In Georgia, we're have massive amounts of numbers and job hours on the nuclear power plant that's being built down in Georgia right now. It runs the gamut, which is why we have to be an all-of-the-above energy union. We have a responsibility to represent the people who belong to our union. And we do that, and we try to do it very well. But if it's an energy project, it's probably got some component of a laborer, hopefully a unionized laborer on it.
Okay. Mr. Barr, our neighbor across the border, you're our neighbor across the border in Pennsylvania, of course. And you mentioned in your testimony the $6 billion ethane cracker plant there in Monaca that's currently under construction. As you might know, right across the river in my district, we're sitting on pins and needles about another ethane cracker plant, potentially in my district. In your estimation, based on your experience there in Pennsylvania, what does that project mean for the economy of Pennsylvania and our region? And what can we expect to see with the project in Ohio?
If you're successful, and good luck, first, the estimates are, the studies are, that area could support probably beyond the Shell facility, probably 3 other crackers. There's enough natural gas there to make that significant of a change. What we anticipate is, in addition to the labor work that's being done on that site now, it's one of the biggest construction sites in the U.S., as I understand it. There will be hundreds of well-paying jobs right at the facility. In addition to that, the feedstock from that factory will make products that every citizen in the United States needs. And we know, we talk a lot about the fact that most jobs are small business, which is true. So those will be, in most cases, small business jobs. But the reality is, a lot of times what it takes is the kind of investment that Shell is making of $6 to $7 billion instilled in Beaver County, the area you're describing, that will take all kinds of other jobs as well. Everything to service the facility, to work on the facility, full-time jobs, the products that come from it. So I wish you all the luck in the world with that. It has been, as I mentioned, game-changing for Pennsylvania in terms of jobs and economic development. And the one thing that I would note is, just as an overall with natural gas, perhaps the starkest thing that I could mention is, one of the advantages of having been around for a number of decades is, I remember the 70s when we had disruptions in our energy supply and lines at the gas stations, but worse, the cost for our citizens and the impact on the economy. And I also spent 20 years in the petroleum industry, and I was asked continually, why can't we use our own resources? We are now. We are now. And what has happened is, if you note with the events that have happened in the Mideast over the last year, 20, 30 years ago, that would have had an extensive impact, negative one, on this country. We saw it barely with a blip, and that's because we've developed our own resources in this country.
I couldn't agree with you more. I spent 26 and a half years in the Air Force, and I was on active duty in the 70s when all of that took place, and I can remember having to stop about every half hour as we drove across the country to visit family to get gasoline, because you could only buy a certain amount, and many stations couldn't even get it. So you are exactly right, and America's ability and our position as the world's dominant oil and gas producer in the world right now today has changed the conversation on the international stage. And so I commend you for what you do, and thank you, Mr. Chairman. I yield back.
The gentleman yields back. The chair now recognizes the chairman of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. I did want to say that I understand the job impacts of pipeline construction and want to thank David Molino from the Laborers Union for joining us this morning. But I'm not asking you a question. I wanted to go ask a question of Ms. Van Rossum. Last week, Chairman Chatterjee said FERC is, quote, losing the PR battle on landowner issues, specifically regarding rehearings and tolling orders, as he announced a reorganization of the Office of General Counsel to more quickly address landowner rehearings. Now, Ms. Van Rossum, in your written remarks, you mentioned that the proposed reorganization may not address the underlying issues impacting landowners. So could you elaborate on that and what you think would be the best remedy for the tolling order issue?
Thank you very much, Congressman Pallone. First off, let me put forth the best remedy. I think the best remedy is that if there is a tolling order in play, the Natural Gas Act should be very clear that the Federal Energy Regulatory Commission cannot approve the exercise of eminent domain or any level of construction until that tolling order has been lifted on any and all parties that have a rehearing request in place. That makes sure that we maintain the status quo so nobody is put at a disadvantage. It also incentivizes the Federal Energy Regulatory Commission to comply with the 30-day time frame for responses that are actually laid out in the law. The proposal that Chairman Chatterjee put forth last week has a very significant loophole in that it says that it's going to prioritize rehearing requests from landowners, but that in all other circumstances, it will only consider rehearing requests, quote, only when time permits. So that means that organizations like the Delaware Riverkeeper Network, the Sierra Club, and others, we will still be subject to tolling. It's very important to note that some of the most important precedent-setting legal decisions that have come out in recent years when it comes to FERC and the exercise of authority have been advanced by organizations like mine, including the oft-mentioned Sable Trail decision, as well as the decision that says to FERC, this was related to the Northeast Upgrade Project further north in the state of New Jersey, that FERC may not engage in illegal segmentation and they must consider cumulative impacts when they're considering projects. Those kinds of legal challenges are not brought by property owners, and yet they will no longer be allowed to advance. So there'll no longer be a check on FERC authority.
I have to move on. I just want to try to get two more in. Mr. Paris, could you elaborate on what it would mean for the landowners on the Spire-Spear pipeline route, which is already in service and flowing gas, if a court ultimately ruled that FERC did not do an adequate need analysis? And 1 minute, because I have to ask the third question.
We've asked the court to vacate its certificate, which would mean that the pipeline has no right to be on their land. I'll leave the legal process to the state process, to state law in Missouri and Illinois, but I would imagine that those landowners would have every right to eject them from their land. I doubt that they would ask them to pull the pipeline up, but I think they would be able to retake their land and use it the way that they intended to.
All right. Then my last question is for Ms. Danis. Do you believe that FERC is providing adequate opportunities for landowners and other individuals to participate in the public comment period prior to a project's approval?
I believe that FERC has a lot of mechanisms in place for what they consider to be public participation, but it can hardly be said to be real public participation in a meaningful sense when there is no opportunity to have any kind of an evidentiary hearing or to examine the data that's in the record. And as far as the public is concerned, the only economic analysis the public is given is the precedent agreements. And the commission does not disclose its balancing inquiry until the moment it issues a certificate, and at that same moment simultaneously denies, for example, a motion for a request for an evidentiary hearing. So the public can submit comments. It is unclear to me what value, if any, the commission places on those comments, because 99% of projects are certificated over serious landowner and public objection.
Okay, thank you. Thank you, Mr. Chairman.
The gentleman yields back. The chair now recognizes my friend from the great state of New York, Mr. Taco, for 5 minutes.
Thank you, Mr. Chair. Mr. Molino, I listened with interest about the issue of infrastructure, and you're very right. I believe if we're going to solve the climate crisis, it's going to require hardening existing infrastructure and building additional infrastructure. So I look forward to working with you and our members of labor that will speak forcefully, I'm sure, to the need for infrastructure. So I appreciate your comments.
Thank you.
Ms. Danis, I heard the exchange with a couple of my colleagues here about environmental impacts as part of the public interest determination process. What is the current legal understanding for considering climate impacts?
So the current legal understanding, as former Commissioner LaFleur testified this morning, is in flux, to say the least, before the Commission. Some members of the Commission understand that for climate change impacts, for example, that they must do more than they're doing, and there must be some way to quantify, and social cost of carbon has been mentioned. And as Commissioner Glick has said, and I think he's spoken most forcefully on it, a public interest determination that systematically excludes the most important environmental consideration of our time is contrary to law, arbitrary and capricious, and not the product of reasoned decision-making. So I concur with Commissioner Glick's view of what the public interest determination requires.
So within that current legal understanding, are a project's contributions to climate change part of its environmental impacts?
Well, for example, in the Pennies project, the Commission disclosed in the EIS the greenhouse gas emissions associated with the project. But it's not possible to compare tonnage of greenhouse gas emissions to dollars on the other side of the scale of economic benefit. So there's got to be some way to understand the environmental impacts and to be able to really take them into consideration in the public interest determination.
And earlier this morning, as you indicated, former Chair LaFleur stated her belief that FERC was capable of conducting this type of analysis in its review. They have information, they can put something together. She talked about doing something, just with the available info she had to try and cryptically put something together. So do you have any thoughts on FERC's technical ability to more completely assess environmental impacts on projects?
It begs reason to say that the Commission does not have that technical expertise. These projects and the economics associated with the projects are incredibly complicated. The designs, the plans, the mechanics of the projects are incredibly complicated. Social cost of carbon is a pretty easy math tool, and it's widely accepted by federal environmental resource agencies as representing the current scientific understanding. So I have no doubt that the Commission has the technical expertise.
Thank you. And Ms. Van Rossum, do you have anything you would like to add in regard to FERC's recent public interest determinations related to climate impacts?
Thank you so much for that opportunity. I have a little bit of a different perspective than Ms. Danis. The National Environmental Policy Act is very clear, frankly, that FERC should consider climate change impacts. And also the DC Circuit has been very clear that FERC should consider the climate changing impacts of pipeline infrastructure. FERC has unilaterally decided that it will ignore the law, the legislation, and the DC Circuit in how it decides to review pipeline projects and render decisions. And I would also note, because of the use of tolling orders, including with the most recent January 31st pronouncement, what will inevitably happen is another case will be brought, like our challenge to the Pennies Pipeline project, where we are bringing a climate change argument, but due to tolling and other factors, we will be prevented from getting a final decision out of the courts until it's too late, until the project's already built and in the ground, which is what happened with the Northeast Upgrade Project when we were victorious in that case.
Thank you very much. Well, Mr. Chair, with that, I yield back.
The gentleman yields back, and Chair wants to indicate that the witness questioning has been concluded, and it was really a thrill to have you testify before this committee, and so I want to thank each and every one of you for your testimonies, and as you depart, just extend you traveling grace as you depart back to your destination. And I want to remind members that pursuant to committee rules, they have 10 business days to submit additional questions for the record to be answered by the witnesses who have appeared. And I ask each witness to respond promptly to any such questions that you may receive. And I request unanimous consent to enter into the following records. A letter from the Industrial Energy Consumers of America, a coalition letter from organizations representing the natural gas industry, a memorandum from the Congressional Research Service, 2 letters from the National Association of Manufacturers, a report from the Center for Manufacturing Research, a report from IHS Economics, a coalition of letters from landowners offering comments on the Natural Gas Act, a letter from the Appalachian Trail Conservancy, a letter from the Congressional Denver, from Congressman Denver Riggleman. Seeing no objection, so ordered. And this concludes our hearing. And again, thank the witnesses. Thank you so much.
You're welcome.